Yes.
But item number 21, my lord, can this be taken up next week, man?
On the prayer made by Mr. D. Pani, learned counsel for the appellant, list this matter. Next week, I don't know how. This much matters only normally comes after a week.
All right.
Lordship, I will allow to move an unlisted bail matter. Only CDs.
Have it tomorrow.
Lordship, tomorrow is a holiday, that's why.
Day after.
Lordship, man is already behind the bar since 5 days.
Behind the bus?
Yes.
Day after tomorrow.
Lordship, only
Wednesday.
CDs to be called for.
Huh?
CDs to be called for only.
May I, Your Lordship?
Before rising of the court.
May I, Lordship? Lordship, I beg to mention item number 14, Your Lordship.
14?
Yes, this matter may be listed on this 23rd of February, Your Lordship.
Okay, that
Yes, Your Lordship.
review matter.
Lord,
When do you want it?
23rd of February. This month.
On the prayer, on behalf. You're making this prayer? You're for?
I'm for this one, Your Lordship. On
Respondents.
behalf of S. Tapping, Your Lordship.
On a prayer made on behalf of Mr. S. Tapin, list this matter again. After 23rd would be Friday. We'll have it on 27th. On 27th to 2020.
How about this, Your Lordship?
Lordship, I beg to mention 2 unlisted bail application, 438 bail application.
Today.
Yes, Lordship. Obliged. Lordship, I beg to mention item number 20. On behalf of Priti Dara. Item number 20.
On behalf of Mr.
Priti Dara.
It's not keeping well.
Yes, Your Honor.
On the prayer made on behalf of Mr. T. Tara. He's appearing for which respondent?
Respondent number 1, 3, and 4.
Learned counsel appearing for respondent numbers 1, 3, and 4. List this matter again after 2 weeks. Yes.
Lordship, this is a bail application under section 439, Lordship. This is a second
We'll
bail.
call for the case diary.
Should we have the in prayer for consideration?
Let the updated status come. Because see, what you have done is not very conducive. It's not just taking some drugs and having it. You are basically destroying evidence. So we'll have to be sure that that act did not have any other angle. Because these are evidences which you have heard. Your name?
G. Talo, Lordship.
Heard Mr. D. Talo, learned counsel for the petitioner. Issue notice. Returnable on. How many days will you take?
Your Lordship, on 23rd, Friday?
Friday.
Yes.
We'll have it on 28th, 27th. Will it be fine?
Yes, Your Lordship.
27 to 2024.
Lordship.
The case diary in case of Bomdila Police Station case number 1 of 24 under section 381/408 IPC read with section 27 of the NDPC Act be called for. List again on 27 to 22 with the case diary. For the case diary.
Lordship, if I may, Lordship.
Huh?
Lordship, actually, if I may, Lordship. On 27, Lordship,
Any date you convene, whenever you want it. 23rd will be fine.
23rd is good, Lordship.
23rd.
No problem.
Wait, please, Lord.
Yes, Mr. Pan.
My lord, is the 438 bail application. The FIR is at page 14.
I think 2 and 3 are basically the same.
Yes.
There is no ingredients against these 2 ladies with regard to that assault, right? Or there is something, madam.
No, as far as
We have to
the
see the
applicant is concerned, there is nothing.
Just go through the FIR. It's
The
verbal
only-
abuse.
Only verbal
Yes.
abuse.
Verbal
Only
abuse.
verbal.
No sections are incorporated.
Yes.
And the man against whom the assault is alleged is not before us.
No,
Yes.
he's also before.
Where?
Item 3.
Three.
Yes.
Marge Pakam.
Yes.
Who is the man?
Yes. Yes.
Okay. We'll allow two.
Pardon, Your Lordship.
We'll allow two. Three, we will call for the case there. Right?
Yes.
3, my lord.
Entry.
Yes.
I'll dictate. Huh? Mariam. 3, just make a note. Allowed with conditions. And
Two- two-
no,
two-
two allowed with condition. 3, interim. Case diary to be called.
Obliged.
Diplo.
My lord. Next day.
Madam, how long will it take?
On 27th, Your Lord.
27. Both
Well.
entries.
Diplo.
Just give me that note. Huh?
Obliged.
Item number 4.
For me, please.
Yes, madam.
The anticipatory bail has been filed against.
Hmm?
Anticipatory bail has been filed
Hmm.
on behalf of the appellant
Hmm.
who is anticipating arrest in relation to FI Rupa.
Okay,
PS
that incident wherein you are suspected to be inside that vehicle.
No, Your Honor. The petitioner herein has not been mentioned anywhere in
I
the
know that.
FIR.
But the police now is behind you. That means the suspicion is that you were also one of the income persons in the vehicle. Right?
No, Your Honor, that was not disclosed yet. Because
That's not disclosed. But
because,
otherwise,
we have
why
to
the
be
police
very-
will be behind you?
there may be any disclosure statement that from the
That's why we would like to examine that. We'll call for the case.
Yes, sir.
You have it on 20.
However, Your Honor, there are judgments of the Honorable Supreme Court as well as the High Courts of.
You want to say about 41, section
The-
41.
No, not section 41, that even though the person is, if the person is not been named in the FIR or he has not been arrested from the spot, in such case, only the disclosure statement of the accused persons cannot be
Madam,
taken
let
into
us
consideration.
satisfy ourselves. What is the basis for
Yes,
the
Your Honor.
police to have a suspicion against you in this matter?
Indeed, Your Honor, then in that case, interim bail may be given.
We will consider that on 23rd. Today is 19th, 23rd we are fixing. 23rd. You were out for such a long time. Let's see 23rd what happens. Issue heard Miss MS.
T.Y. Bhutia. T.Y.
declare,
Bhutia.
and also heard Mr. BP. List again on 23 to 2024. Case diary in connection with Rupa PS case number 15/23 under section 20 bracketed C and 25 of the NDPS Act be called for.
Our next date would be 23. 23.
We'll see on 23, ma'am. We only want to remove that apprehension why you are there.
Item number 5. Wait, please. It's 438 application, Your Lordships. I'm basically, Your Lordships, FIR.
Why did you give a check?
No, I'm not giving the check. No,
You have?
No.
See the next case.
no, Lordships. The next case is he's friend of mine, but there's a business transaction. I have business transactions, but I have taken some money from him. That is why I've given the check. Now, in this case, Your Lordships, the FIR did not disclose that involvement in the theft case, Your Lordship. And I'm going to return the amount as soon as possible. If I'm behind the bar, the informant will not get the money. And Your Lordship, 41A notice and as well as the due procedure of law, it should be mandatory on the earnest criminal judgment, Your Lordships. Now, the amount which has been debited from his informant account, there is a mandatory provision.
No, one thing you tell me.
Lordships.
If there is somebody else debited, let's assume somebody else, Mr. A,
Lordships.
did this
Lordships.
mischief with the informant.
Lordships. Lordships.
Let's hold it.
Lordships.
But why was the amount credited to you?
That is the
You have not said anything
No.
that you said you don't know the informant or the other person.
Lordships.
You are the beneficiary. You received that amount in your account.
Lordships. And I'm ready to pay the return the amount, Your Lordships. I'm ready to pay the return.
Why did you not do that immediately when this had happened? If that was your bona fide belief.
Your Lordship, the incident has been taken place in the month of in February 6th.
Hmm.
And Lordship, after the police has visited my place, then I have come to know that there's some amount has been
Now
credited.
your account is being freezed from that day by the bank. Your account is freezed.
Please, and since I am knowing.
And you have not taken any steps.
I'm ready to steps. I'm taking ready to steps immediately, your lordships. If I'm getting behind the bar, your lordships, the information will be lost, your lordships.
No, if you being outside also, you can do nothing because your account is now
No,
freezed.
no, because your
Frozen.
lordships, I'm ready to help out the every possible solution.
Yes, madam, what do you say?
Lordship is partially admitted that he have done lordship because he ready to pay lordship. Lordship that
Not
read
only
the
that,
CD.
he has made a further transaction of that.
Lordship. That's why lordship.
If the second case was not there, we may have come in your favor. But the second case gives a different dimension.
Lordship, no.
We will.
Lordship,
have it
call
together.
for the CD.
No, there
lordship.
is
We
no-
call for the CD lordship.
Lordship,
Call
no,
for this.
there is no conspiracy behind the entire thing. The entire theft, the check has.
Mr. Counsel,
Lordship, can you,
that is what we want to be satisfied with.
lordships?
That this is not another case of this fraudulent bank transactions.
No, there is a PPS
And
system,
see-
lordship. PPS system has been frauded, lordships.
You issue checks. Do you issue checks?
Lordships,
No?
lordship.
Have you gone to your bank and made that signature that if I don't disclose it, nobody does
No,
it?
no, no,
So
no.
that cannot.
There is a notification in
Maybe.
the RBI guidelines is there.
It's
If
a guideline.
amount, lordship,
It's a guideline. Even I issue checks. They come that this has not been followed.
there is a cross
But
checks.
that by itself will not prevent the encashment of that check.
No, I am not encashed. There is a transactions between the next person. That is why he has come before this honorable court.
Then why was the amount credited to your account? You have not said that this amount was credited to my account by mistake. Huh?
No,
You have
no,
not said that.
no, account. I have, since I am a pretty businessman in Assam, your lordship, doing my business very well. Maybe your lordships, these persons who has been, these named persons, the main culprit, your lordships, who has, the manager, who happens to be manager, he may got my account number somewhere, the business, he, for his benefit, your lordships, I don't know, your lordships, for any other transaction, he could-
Don't argue further.
lordship.
That will make again.
Kali gives, since,
We will have this matter on 23rd.
lordships,
We will consider. Madam, you get your CD on 23rd.
at least.
Both the cases, 5 and 6.
At least 41 notice has not been complied with the Ernest Kumar's judgment, your lordship. If I, lordship,
We will look into everything on 23rd. We'll pass orders. Or if you have any difficulty on 23rd, we'll have it on 27th. 27th would be better. You will have to come back again. 27th. It's okay?
well, the kindly, lordship.
Issue heard Mr. So-and-so, Learned Counsel, so-and-so for years for day.
This one is better for me.
23rd. Call for the CD in
In
Chimpu PS case number 13 of 2024. Under section page 1 में मिल जाएगा. यहाँ से मार देना. List again on 23rd, 23 to 2024 for CD.
Name is there. Lordship.
Like
23rd we will finish it up. Don't worry. Item number 6 also same. 5 and 6 are same. Right?
For item number 6.
6, okay.
I have some humble submission, lordship. Few lines.
Please come.
Map logic, please, your lordship. Lordship, my humble submission is that, your honor. I am the owner of Kuntola filling station. On 8th of February, I deposited the check which I received from one.
Sim,
Yes,
you
lord.
have said that the accused has a debt with you of 20 lakhs,
Yes,
right? So you
But-
are a petrol pump,
yes,
if we can understand it in a more.
yes, lordship.
He has a dues of 20 lakhs.
Yes, lordship.
In your application, you have not even specified the manner in which that dues have come into. 20 lakhs of petrol, there has to be a transactional history.
Lordship,
It cannot happen overnight.
lordship,
You have not said anything.
lordship, actually, the petitioner did not give me.
And
the
see,
receipt.
Mr. Counsel, the dues you have said in the petition here is because he had taken petrol from you or diesel from you, POL. But you have not said the period. You have not said how this 20 lakhs amount, 1 liter is 93. So how many liters, how he has taken, what was the transaction? Nothing.
Lordship, subsequently on 10th of February, I had lodged one complaint in our Sotia police station against this Tridip Soikia. That
You
is
forget
mentioned.
the complaint you have lost. He has given you a check of 20 lakhs.
Yes, Lordship.
You can show from the records that this transaction is for, these are the transactions involved for which he is liable for 20 lakhs.
Lordship,
Nothing is there.
some this bills are there, Lordship.
But in your writ petition, sorry, bail application, you have not. even-
Yes, I did not mention
mentioned
because I got these receipts after filing this. case.
This does not inspire confidence. This does not inspire confidence, man. This will not inspire confidence. Same order. 23rd,
Lordship, interim may be given. So
23rd.
oblige, Lordship.
My lord, just now I have been instructed by the petitioner to withdraw this bail application.
I think when I was here last time, similar matter I had dealt with, I suppose. That director's case, I think I gave him the bail. He went up to Supreme Court, then came back. Anyway, on the, your name?
N. Pada.
N?
N. Pada.
N. Pada, learned counsel, appearing for the petitioner submits that he is under instructions of the petition not to press this bail application. Accordingly, the bail application stands dismissed as withdrawn. Yes.
May please, your Lordship. Lordship, this is section 482 application seeking quashing of a complaint case under section 138. This Honorable Court, by order dated 2011-2023, was pleased to stay the proceedings before the learned trial court. What has happened, my lord, in this case, if this Honorable Court comes to
Yes, who is appearing for the private respondent? Informant?
I'm for the respondent, the complainant.
Complainant. Okay, fine. We can proceed with the matter? We can proceed with the matter?
Yes, Lordship.
Yes.
my lord may kindly come to annexure 1, page 21.
Now, tell me one thing. This check was given with certain conditions,
Yes, Lordship.
right? And the agreement between you was that moment he receives money,
Yes, Lordship.
he will clear the amount to you.
Yes, Lordship.
And his case is that after that execution of that agreement, now if that is there, money not released, you cannot utilize that check,
Yes.
right? You have made a statement in your reply or somewhere I saw it,
In my complaint.
that when you went to the municipal
Yes,
authorities,
sir.
you found that the amounts were declared
Yes.
clear to him. He has not accepted that. Just demonstrate that the money was received by him. Then that agreement comes into force,
That's what, Lordship.
right? That's the case.
Lordship. Lordship may kindly come to page 60, Lordship. Doctor,
60.
this page 60. This is a certificate issued by the municipality. After the amount that was issued earlier, subsequent to the agreement, no amount was released. This is a certificate given by the.
So you don't deny this agreement.
I don't deny, Lordship, I don't deny the agreement.
Then you come to page 37,
Page 37.
para 4.
Page 37.
Correct me if I am wrong.
Yes, Lordship.
4.
4.
They said
That
amount will be given so
by
and so as and when the pending bill is cleared by so and so. So it is in terms of 4 that 5 has come into place.
Yes, Lordship.
So without 4 occasioning, 5 cannot occasion.
Yes, Lordship.
So show me that 4 has occasioned.
That's what, Lordship, coming to my complaint petition, Lordship, as Lordship has pointed out, when I had visited the municipal office.
But there is a certificate at page 60. Have you dealt with this? Have you filed a reply to this here? No.
No, Lordship.
Then you deal with this.
Lordship, since I have made a special abandonment, since we are not aware of the payment being made to them.
Fine. He has now, maybe there is a misunderstanding. That's a different thing. But that security check is a security check.
Yes.
Till now.
Yeah.
Once 4 occasions, clause 5 will come into place. You can place that check for payment. Then it is dishonored, everything will be there. But you yourself undertook that till he gets the money, you will not use that check.
Yes, Lordship.
So you jump the gun, according to him.
Yes.
And in support of that, he is brought on record page 60.
Page 60.
that dispute this, file a small affidavit, we'll have it day after.
Yes, Lordship.
Huh?
Lordship, before that, Lordship, this matter, they had filed an IA before the trial court with the same
For quashing,
for discharge.
discharge. That is no material. We'll consider this. When can you dispute this? Just dispute that.
Okay.
If you can show that the money has been received, we'll set aside this. We'll dismiss this application.
Yes.
That's all.
Lordship, on that, we can file it on 23 or 27.
23 or 24? We'll have it on 27, 28. What do you say? When can you come down?
28.
28. 28.
Yes, Lordship.
On the prayer of Mr.
V. Jamu.
V. Jamu, learned counsel appearing for the respondent. List this matter again on 28 to 2024. Mr. Jamu is permitted to bring on record his pleadings. Bring on record his stand by way of filing an affidavit. Mr. Jamu shall specifically deal with the contention of the petitioner that the municipal authorities had not released to him any amount after the signing of the agreement, deed of undertaking on 6/9/2020. That's your stand? Deal with that.
Developer.
Item number 9.
Yes, PP. How do I approach this case?
My lord,
The parents have come up and said nothing,
yes, ma'am.
but the allegation is very serious. If the statements which were recorded at that point of time also indicates
Yes.
happening of this incident. In this matter, how would that decision in that Narendra Singh and all be applied here?
My lord, if we go through the judgment of Lakshmi Narayan versus the state of Madhya Pradesh, my lord. The
Which
Lakshmi Narayan versus the state of Madhya Pradesh,
Lakshmi-
as well as Kapil Gupta, my lord. The parameters are very clear. My lord. And those cases arising out of a special statute like NDPS or the POSCO, that cannot be considered, my lord. But since, my lord, there's a coordinate judgment of this honorable court, though my lord is not binding upon that judgment.
Just show me. Just clearing my cobwebs. We wait for a moment.
This even matter was in respect of Section 8 of the POXO Act.
But only thing is, Mr. Bora, some assistance. These matters are very, very new for me. Gyani Lakshmi Narayan Narendra says that quashing can take place by this court if the parties come. But those are cases basically with the normal IPC sections. Wherein compounding is not permissible. Take a case wherein it is a case of POSCO. And serious allegations made. But subsequently, the informants come and say that was under the misunderstanding. We have made that. And they come together before this court, along with the accused, saying that please quash it. How should this court approach the issue?
They have to approach the trial court during the trial. There is no option for the quashing now. During the evidence, they can say whatever they like.
Tell me another situation. I'm finding it very interesting here. There is an allegation by the mother. That's another matter. Father committing an act on the child. Child supports that. POSCO case 6 registered. Subsequently, during trial, the mother and the child, they changed their version, declared hostile. Now, what would be the impact, being a special law? Does the judge have the power to go back to that 164? Doesn't have, can't. And after declaring the person hostile, no cross was also put. So that's the end of the matter.
That's the end of the matter.
And the man, if he comes for bail, what would the approach of this court should be?
Then no option to grant him a bail.
Yeah, I also was thinking of that.
POSCO Act also, there is a provision, madam, that the lady, the victim, if he resigned from the earlier statement, she cannot be prosecuted also
She cannot be prosecuted.
for making a false statement.
It will not be there. But what about the informant? She is not a POSCO. She is
She is major.
Major.
She can,
she can be
she
prosecuted.
can, but not the victim if she is a minor.
Thank you.
So in this case, well, I think the only option for the go back to the trial,
Oh, trial,
during
trial.
the trial, my lord, they can depose,
They can depose.
depose whatever, but that's.
Thank you. Yes, Mr. Consul.
My lord, what's for?
These are all
Yes,
just
ma'am.
tentative.
Yes.
You have your case.
Yes, ma'am. Now, my lord, to my humble understanding, my lord, every case cannot be made
Equated.
into a one engagement.
Yes,
He does not have any grievances. Stepmother is having grievances.
yes.
Now show me the
Yes.
FSL report.
In fact, your lordship,
That
the,
will settle.
And on that day, even I was not in the country.
You have given your passports.
Yes.
in fact, your
No,
lordship,
Mr. Bora, that FSL report,
Yes,
if there is an FSL report saying that it's a forged signature, you are done with. If it is not forged, the whole case falls. And this case has got nothing to do with the matters in Bihar
yes.
about
nothing-
your this
Yes.
alcohol being
Absolutely,
transferred. And those allegations are not.
not there.
Allegation here is he forged.
Forged-
There was an account opened. He then showed it to be a
or,
what do you call power of attorney with that other person,
Yes,
son of the informant,
yes.
and the money was being transacted. And the
And
problem
there-
for him was because of that he got implicated in that BR case. That's the projection.
yes,
Now, the allegation is, and the bank people also says he has done it. Now, if he has done it, he was sitting there. It is his signature. Even if he says signs as Preme Dorji. FSL can find that out.
Yes.
Where is that FSL?
yes, in fact, your lordship, on the last occasion, updated CD was called for your lordship. On the previous occasion, your lordship, they had short time to file their affidavit. In that CD,
Forget all these things. It boils down to that. Mr. Borap, is
Even
any
then, my lord, my only question is that they say that they have disowned that power of attorney. By virtue of the power of attorney,
Money-
they are receiving the money, the thousands of crores of money, and they are
Actually,
not
bank
denying,
statements- Bank statements are there.
and then they are not returning also. In the other
You are
case,
saying
as
so.
lordship has pointed out,
Private complainant.
why he has not returned it, if that be so,
Why
why he is
why
receiving the money?
Why was the money being received by you? Best wholesale.
My lord,
I think it's best wholesale.
Yes.
he has not received any single amount from the account of.
Where is that money which was withdrawn? It was a online bank
By
transaction.
him only, my lord. Both the accounts are being operated by him only, my lord.
That means you mean to say the money that was shown to be withdrawn in your name
My lord,
is going to him only.
He has, my lord, the.
And the account I have opened, yes, and in.
You are protected, interim protection.
Yes, yes.
And now the
your
money.
lordship, CD was called for your lordship. CD, updated CD has not come, your lordship.
Or not come.
Not come, your lordship.
But I want that FSL report.
Yes, your lordship. That's why I was pointing out, your lordship, on the previous occasion, the only objection made in the CD was that the original power of attorney is with the accused person.
But he has
He has,
subsequently given a letter to you, which he says that these
Yes.
are documents
Yes.
not with.
therefore, updated CD was called for, which has not come, your lordship. If your lordship may give short date to
When
get.
I get people like Mr. Bora, so we also try to feed on him,
Yes,
to learn something.
yes, your lordship. If I may
Ma-
pray, your lordship, a short
Ma-
date may be
The
given for.
interesting point is now, the money has now stopped going to that account. Now it's diverted to the informant's sister.
Sister,
Now sister come into the role.
you have
And
brought that
she-
in additional affidavit. I think
Yes,
you have
yes.
brought.
Now the sister is receiving the money and they are disowned. They have no objection when receiving the money. So much of money they have taken from me. They have not returned it.
It all boils down to that Bihar incident.
Yes. And the Bihar incident also now it has been
We are out now.
Now we have filed a
13,
question that has been, we have filed. And what happened when both of us in the custody in the Bihar, that time the stepmother has filed this FIR. So lordship can understand it.
That's the only thing which created a doubt.
And now he has
She
filed an
could have
affidavit.
waited till the man came out,
Yes.
and he could have filed this.
Now Dorji's affidavit, my lord.
You can apply, has been filed.
My lord,
That would be
Now-
no FIR.
now
Same
Dorji,
issue.
Dorji has filed an affidavit also
Hmm.
from the Bihar.
Ah.
From when he was in the custody, that
My second additional.
my second additional affidavit, my lord,
Dated 10th February,
dated 10th February,
page number 24.
page number 24, my lord.
Hmm. You can come to page 40, the FIR itself.
Yes, yes. Now, Dorji,
And here he literally says he does not know him.
yes. Now, from the custody, my lord, he filed this affidavit, Dorji himself, my lord. From Aurangabad.
It was not done on his behalf, madam. The first FIR was done on the own motion of the mother.
Yes.
It does not say that FIR is this, I am signing it. No. Anyway, get your CD. When can you come, Mr. Bora?
My lord, as soon as on 28th, my lord?
28. Fine.
Yes, I'll make sure the updated sheet is.
And there are certain allegations against you. We'll only have a prima facie. We can't go into the fruitfulness of this thing. Prima facie view. If you have any other pleading to make with regard to his contentions, bring it on record.
But one more prayer, my lord. What happened, my lord? In the meantime, every time this case comes into the High Court, the learned CGM, out of his jurisdiction, my lord, directed us to appear before the court, which is not the direction by this honorable court while granting the interim. But the learned CGM of his own, my lord, directed us to appear each and every time when the matter is fixed before the High Court. Today also there is a direction I have to appear before the CGM. That was not the direction by the original interim order.
It was only before the investigating officer.
Yes. But the CGM of our own, my lord, taken up the matter.
Charge sheets have not been filed yet.
No.
Not yet.
That's why, my lord. Then appearing every day, we are appearing. And we have to take permission from her to go out. Whereas the original order does not speak so.
That the applicant shall not leave the jurisdiction of the Chief Judicial Magistrate UPR without prior permission. Once you leave with prior permission,
From the
but do you have to repeat that every time?
Every time, your lordship. Because
that
you mean
is
to-
for the investigating officer.
no.
No.
The-
Here it's the word, if you see that order.
Yes, my lord.
The condition.
Dated
That
21/12.
yes.
Hmm.
That
Three,
we
the
have
applicant
to,
shall not leave the jurisdiction of the learned Chief Judicial Magistrate UPR
without prior permission.
without
but-
prior permission. Now, Mr. Bora, it presupposes a thing that before this case,
For
you are here.
appearance, for
You are
Yes.
here always. If you have to go out,
Yes,
say
that-
1 month, you take a leave and you go.
Yes.
If I may
but-
use that word.
Yes, but every time when the case is fixed here, I have to appear before the CGM.
It's good for Mr. Bora. He gets 2 forums in one trip.
No, my lord, that's always difficult for the person.
You appear today. Next
I
time,
have already appeared to.
we will settle it next time. Don't do it. 28th, we will do it. 28th, you want it?
20th I wanted, but 20th I may not, his appearance may not be maybe dispensed with, my lord,
The appearance before whom?
before the CGM.
Will not do anything, Mr. Today. Will not do anything. 28th.
Because
we'll
I
try
am
to-
not taking the permission, I am taking the permission if I go out of but every time when the case
No,
is
where
fixed
are you now? You are in.
here,
No,
but the,
no, you will be here till 28th.
no, I'll go back, I'll take the
Yes.
permission for going back.
You take your permission till when he has fixed the next date.
No, the date is fixed on the basis of the order.
This today, again 28th I have to come, because we have to produce now this order to the CGM. Now, again, so where is the jurisdiction, my lord? The charge sheet has not been filed.
Maybe because of this order, this line,
Yes, your lordship.
this is being.
No, that is for the going out, but every time my appearance for the CGM, when the matter is fixed here,
Lekha. Madam Jimmy,
Yes, your lordship.
so and so additional PP submits that she be granted another week's time to produce the updated CD.
Yes.
Also, the learned PP, additional PP is also required to place before this court the FSL report, if any,
If-
received. Also reproduce before this court FSL report, if any, received. Mr. M. Kato, learned counsel appearing for the respondent, submits that the respondent number 2 submits that he may also be permitted to bring on record any additional pleading on behalf of the said respondent, if so advised. First of all, Mr. Bora, A.M. Bora, learned senior counsel, assisted by Mr. D. Baito, learned counsel appearing for the applicant, has submitted that in pursuance to the order dated 21/12/2023, the learned CGM UPR requires the presence of the petitioner on each and every date whenever the matter is listed before this court in the present proceedings. It is the contention of Mr. Bora that the petitioner presently is residing in Arunachal, right?
Yes.
And
Uttar Pradesh, but we have taken the consent to go out.
hereby and had taken what was the nature of the consent given? It was an open consent or a periodic consent?
Periodic consent, my lord. Last part, lordship, thank you.
Then 29th, what happened?
29 again, we have appeared.
What is the order?
29 lordship, the same order was passed.
But
Then again, he was required to come lordship, and today he is again here, my lord.
And therein he was allowed to go out.
yes,
29th lordship, he was not present physically because he was unwell. So we repaired. On that day, he was exempted. But today again, he was asked to appear, and today he is here, my lord, in this premises.
Okay. Submits that the petitioner has appeared again before the learned Chief Judicial Magistrate appear today and has submitted an application seeking permission to remain out of the state
Residential.
for reasons as apprised to the learned court. Full stop. The petitioner lists this matter again on 28
Yes, sir.
28/2/2024. The petitioner need not petitioner's appearance before the learned Chief Judicial Magistrate appear if the case pending therein is fixed on 28/2/2023 is dispensed for that day. Full stop. Further, appearance of the petitioner before the Chief Judicial Magistrate appear shall be regulated in terms of the orders that would be passed by this court on 28/2/2023 in the present matter. I think that will take.
This is bail application, my lord. My lord, as per FIR.
Until and unless we recall it, we pass these orders. Until and unless we don't recall it, the police does not have the jurisdiction to touch you.
Item number 13.
May I please, lordship?
Hmm.
Lordship, this is a pre-arrest bail application filed by the applicant accused person, Sri Sandeep Kumar Das, for granting of pre-arrest bail in connection with Daporijo.
Oh, that crusher machine.
Lordship.
Crusher machine.
Lordship, here in this.
Forget everything. Just satisfy me on one thing.
Lordship.
You are not Ramesh. You are not Ramesh Ibia.
Yes.
You are not Ramesh Ibia.
No, I am Sandeep Kumar.
Sandeep Das. Why did you sign in place of Ramesh Ibia as Sandeep Kumar Das? Page 19 and 20.
Lordship, he was also there before the.
And therein, the signature is
Lordship.
that the total money has been paid,
Lordship.
which the informant now disputes. Where is that material? Why have you not given it to them?
Lordship, total contract.
You come to page 19.
Lordship.
Now this agreement witnesses as follows. See B.
Lordship.
Madam, just see. Right? This is an agreement between one Mr. Agarwal and one Mr. Ibia.
Yes.
Right? B consideration. The total purchase price which has been paid by buyer to seller for the acquired machine is so and so, which has been paid white cash. Right?
Lordship.
Now you sign this in place of Ibia as Sandeep does. That shows. That shows.
Lordships, the
The CD is here, madam.
Lordship, yes, Lordship. Lordship, as per the city Lordship, 141A, the notice being served, but they did not turn up.
They did not turn.
Yes, sir.
Lordship, we have not received the copy of 41A.
Ask your IO to personally serve it.
Lordship.
And anything against this Manoj Gogoi here?
Lordship,
Because they have brought on record a person called Manoj Gogoi who was the intermediary.
Lordship, their statement been recorded, Lordship, complainant as well as the
Recorded.
victorious Lordship.
Just find out.
Lordship.
And that 141 state notice, how it was served, anything is there?
The notice being served, Lordship. Before the Lordship, IO at Dapoji PS Lordship, said dear Lordship. This is notice, Lordship, and
These are the statements.
Lordship. The victim as well as the informant. The both are husband, wife, Lordship.
And what made the wife make that? Why didn't the husband come forward? Not at this stage.
My lord, IO may be given direction to serve 41A notice. That's
We'll
because
make
the-
an observation. We'll make an observation. This was rejected. I'll pass the orders. Yes, next.
Deep-
Item number? Yes. Yes, Mr. Kaushik. Who is opposing you in this? Yes. Now, one thing. You went to that larger body of Gamburas, right?
Yes.
Larger body. Your case is that the Gampura of my head Gampura and Gampuras of my village had given me the order. But it was not being implemented, so I went to the larger body. Whether the larger body has jurisdiction, no jurisdiction. How did you approach that body? Orally? Huh? This order of the Gampuras were not produced there.
The Gauburas.
Original order.
Your lordship will see, very interesting. Who constitutes this larger body?
The same Gaumura.
No, I'm not on that.
Well,
I'm not on that. That we will see.
Well.
I've seen that because he is also a constituent there,
yes,
right?
yes.
But how did you approach that body without this order? Because I don't find anywhere that this order being produced before that
Like,
larger body.
No, usually what happens, my lord, in the Kabang decisions, my lord, they don't keep these records, my lord. The records which they take the hearings and all, they maintain it in a proceeding book. Now, this body, the larger body, which constitutes the three other Gauburas, who has certified that they were present and they have acknowledged that fact. That is 13.8, the order was passed, that these bodies are not, it's not that they don't know it.
So the second body, intermediate body between before the court, matter reaches the court and the Gaumbura, the big head Gaumbura and the other two Gaumburas. This intermittent body was apprised of the order existing.
Exactly.
And then it passed its decision.
It passed it.
Where is that decision?
The
Farman is there.
No, that's a summon. That's
And thereafter, where is that order?
If your lordship will find page 52.
This is that larger body's order.
This is the larger body.
Where is that?
Now your
that
lordship.
First order.
First order is page 50.
50.
Page 50.
No.
Yes.
The order dated 13/8/2021.
Yes. This is 13/8/2021.
This is a reiteration that we passed an order on 13/8.
13/8/2021.
Where is that order of 13/8?
That's 13.8, my lord. It has been certified in the first paragraph.
No.
Yes.
No.
Your lordship will
This is to whom it, this is a certificate.
This is a certificate.
Saying about existence of something.
Yes.
Where is that something?
No, that existence of that something is first paragraph. They have certified that.
I got it.
My lord.
There has to be an order somewhere.
No, no formal, no written order was passed. It was what?
How can that?
My lord, this is where how the Kabang functions. My lord.
No. If they don't pass it, I got it. They have not given you a letter. Say, I'll call it a letter of allotment. That this land is yours. But they in their proceeding book have reached a decision.
Possibly.
Why is that not being referred to?
Because your lordship will kindly appreciate one thing. My lord. What is the appeal for?
We'll come to that.
My lord.
We will come to
My
that.
lord. Now
He has not challenged the first decision. If there is no first decision, why should he challenge?
exactly. But when this order was brought to the notice in the appeal, he could have challenged that order.
See,
That was not done.
see,
My lord,
see,
in a
this-
227 jurisdiction, my lord, your lordship is exercising a 227 jurisdiction. My lord, my point of challenge before your lordship is that the learned district judge, while passing the order, has interfered with the order of 13.8, the certificate which was not under challenge. First, second, my lord,
This is never under challenge before the
exactly, and that the learned district judge has also acknowledged that it is not under challenge. My submission was recorded that this was not a challenge, and
he has
therefore
then
it cannot be.
proceeded.
But second, my lord,
But he in the final paragraph interferes with that also.
it refers with that also. First ground of challenge in this
This is that, why, how could you interfere?
My
So my question
Miss.
to you,
My lord.
where is that 13/8/2021?
No, 13.8/2022 would have come on a later stage because Arunachal Pradesh Civil Code Act.
Can you
confers
show
a-
me that act that there is no requirement of anything being reduced to writing in this circumstances?
No. What I'm saying is, my lord, Arunachal Pradesh Civil Code Act confers a jurisdiction upon the district judge to hear the appeal.
This is an act of 2021.
My lord,
Huh?
2020.
So show me the provision here wherein the Gaumbura body, what is that body called?
It may have different name in different parts.
No, this here it is called SOPA, right?
Dirang Sopa.
Huh?
Dirang Sopa. And the
Dirang SOPA is the bigger one.
Dirang
SOPA is this
No.
normal one.
No. Normal one is a lease village.
List
village.
SOPA.
Lease village authorities.
Okay, list
Now
village
the
authorities.
larger body, and there's no dispute. In fact, if your lordship will see from their appeal itself, they also acknowledge as this body. They also say that
No,
Dirang.
they have made a statement there that on the date fix which you say the order was passed, you had not come, right? You had not come and no proceeding had taken place.
If your lordship will kindly
Right, that
just
is your
bear me-
time, Mr.
my lord, kindly have a look at page 29. There,
No, show me from this rules.
my lord,
29 will go.
my lord,
I'm making a note of 29. You can take me to
my
29.
lord, my lord.
But show me from here that nothing is to be reduced in writing or an order is not to be communicated.
My lord, that is not so clear. It is a act of 1945.
What is this then?
No, Arunachal,
Civil Codes Act. No. Oh. What is the name of that act?
Assam Frontier Administration of Justice Regulation 1945.
Assam Frontier.
Yes.
53.
This act confers a civil power, the power of civil jurisdiction to the village authorities.
Okay, show me that.
Well,
5(1).
my lord, regulation 44, how this hearing are to be conducted. All suits tried by the village authorities shall be decided in an open darbar in presence of parties and at least 3 independent witnesses. The deputy commissioner or assistant deputy commissioner may direct village authorities to report their proceeding in any case or class of cases in any way which may appear to him to be suitable. Save as required by such direction, no record of any proceeding shall be maintained. If there is no direction, so no record is maintained. After hearing both the parties and their witness, if any village authority shall forthwith pronounce a decision, they have to pronounce the decision. My lord finds regulation 40.
I got it. 40.
Yes. And that decision was pronounced on 13A. And what brought me to the Dirang Sopa was 14A.
Because
again, they again tried to encroach. And I was suggested by this least village authority that you approach the Dirang Sopa because it happens to be the highest body. And in page 29, well, the learned district judge went into the jurisdiction of the Dirang Sopa, but it is no one's case, well, that the Dirang Sopa do not have jurisdiction or it is a body which does not exist in law.
Now show me.
Well,
where is that direction which you say refers to 44(2)?
Well,
which are the classes which have been taken out of that?
Well,
classes of cases which are taken out of 44(2).
Well, that possibly, my lord, I don't know whether there is.
Because otherwise, it will be a dangerous proposition.
True. But what I am on before your lordship.
There can be a situation like this also. The Kebang may declare orally that Mr. Kaushik is the owner. But tomorrow, on a challenge, they may say that no, we have pronounced in his case. Where is the independent witnesses?
That stage did not have reached in the
because they have not been.
No, the least village authorities, Gauburas, they were made a party in
I'm not on that. I'm not on that.
It was they who had to answer this.
Okay. Now, all suits tried by the village authorities shall be decided in open darbar.
My lord.
By these 3 people.
My lord.
In presence of the parties. Who were the at least 3 independent witnesses?
My lord, that what could have been said by the village authorities because they were a party.
Our purpose.
My lord.
Because 227, I have to see whether that order was passed with in the manner required. That means it's an order passed with jurisdiction.
My lord.
Right? That's the only power I have.
Absolutely.
In fact, that 13(8).
No, my lord. 13(8) is not a challenge before your lordship.
Forget it. That
challenge.
No. 13(8) has been interfered with.
Yes, it has been interfered with. So the order of interfering, that is challenged before your lordship on 3 grounds, my lord. To kindly appreciate. First, the learned district judge exceeded the jurisdiction to the extent of interfering with an order which is not put under challenge. First. Second, my lord, the learned district judge arrived at a conclusion that the Dirang Sopa did not have any jurisdiction and the law does not, in terms of law, this body does not have any existence. Third, my lord, the most important one for which I am before your lordship is that Arunachal Pradesh Civil Court Act confers a power upon the district judge in an appeal, either to dispose that appeal or to proceed de novo. Now, my lord, what I am aggrieved by this order The last part of the order, your lordship will kindly find. The impugned order which is under challenge, page 59. Page 64.
Got it.
My lord.
You mean to say, by this order, there is no list.
By the order, there is no list. That is okay. Second part of the order, as a result, the suit shall be tried de novo. That is within the power of district judge.
But de novo what?
My lord, de novo of the proceeding. That is the issue with regard to the title which was raised by both the parties. The appellant is at liberty to present the plaint within 14 days, as a plaint is an appeal petition is not technically sound for deciding the suit. Now, moment the learned district judge gives the liberty to the other side to file a plaint as per section 26 of the CPC, it is an institution of a new suit. Now, the learned
This happens to be a return of the suit.
Yes. And the district judge, while exercising a power, now have usurped the jurisdiction of an original civil court, which actually lies with the civil judge.
Now, tell me one thing. In this code, when it says that the matter can be, where is that provision with regard to that?
I'll show. Section 15 deals with the power of appeal under this act. My lord will skip 1 and 2. My lord will come to
Section?
Section 15, subclause 3.
Yeah, this the same act.
My lord, Arunachal Pradesh Civil Court Act 2021. If your lordship is holding the same book, it would be page.
I just missed it.
The first act itself in that book.
No, this is Bengal, Assam Frontier Administration of Justice Regulation 1945.
It is Arunachal Pradesh Civil Court Act. My lord, it is
Arunachal Pradesh Civil Court Act. This one.
Roman 16 volume.
15 appeals.
Yes, 15 appeals. My lord will skip 1 and 2 because it relates to the original suits. Appeal from the decree order passed by a court of civil judge in an original suit or proceeding of a civil nature shall, when such appeal are allowed by law, lie to the court of civil judge senior division of the district. Provided that any appeal on civil suit pending in the court of deputy commissioner shall be disposed by the concerned deputy commissioner under the provision of Assam Frontier Administration of Justice Regulation 1945 as expeditiously possible, but not later than 1 year from the date of coming into force of this act. Now, proviso. Provided further that the date of commencement of this act, in case of an appeal is preferred against the judgment of a customary court in a court of district judge or in a court of additional district judge, as the case may be, the district judge or the court of additional district judge may dispose of the same or proceed with the case de novo. So till either the court could have decided the issue of title in that appeal itself by proceeding de novo, or upholding the orders of the customary.
So
two way. Now, the moment the district judge allows the
file a plaint,
the appellant to file a plaint,
beyond the provision.
my lord will kindly find section 26 of the CPC. My lord finds 26.
Presentation of a
On presentation of a plaint. So on presentation of the plaint, this becomes an original suit. It's a regular suit before the district judge who has usurped the jurisdiction of an appeal under the Arunachal Civil Court Act against a customary court. And very interesting now, my lord.
When was this appeal filed?
This appeal, the appeal before the district judge, my lord, it was filed on 15/9/2021.
And when did this power come into being? 12. Okay. How will this provision be? This amendment, this new one, this thing came into effect on official gazette. It was published on 12/4/2021. So on the date this came into effect, this suit cannot be said to be pending.
15-9, this appeal has been filed on 15-9-2021.
15-9.
15-9.
15-9-2021.
So the appeal that lies before the district judge, because earlier the position was.
Just. This act called the Arunachal Pradesh Civil Court Act 2021. That's the act you are referring to?
That's it.
This came into being on 12-4-2021. 12-4-2021. Now you come back to 15, that last provision.
My lord. My lord.
Provided that from the date of commencement of act, in case an appeal is preferred.
Against the judgment of a customary
Okay,
court.
this will be continuing.
Correct.
It's
Because
not that this
earlier-
appeal is pending on the date when the,
Exactly.
because the appeal from the customary court will not lie to a
Deputy Commissioner anymore.
direct or district judge.
District. Earlier the position was the appeal used to go before the Deputy Commissioner. Now the first proviso, the first proviso of subclause 3, it deals with the pending appeals.
Provided that any appeal on civil suit pending in the court of deputy commissioner shall be disposed. This has not got nothing to do with
No. So this is a fresh appeal.
provided further that, no, this is a appeal not from a civil suit, but from a civil court, but from a customary court.
Customary.
Provided that from the date of commencement. Now, other than the customary court, application of CPC, only the deputy commissioner was there, or the additional deputy commissioner also had some powers.
No, we had a civil code.
Civil code here.
Yes, civil.
So the additional deputy commissioner also had some powers,
Yes.
or the executive magistrate,
Right.
or whoever.
Right.
Appeals used to go up before the authorities. So second proviso will be in that. Third proviso would be the
In relation to appeals against the customary courts. Now this is purely an appeal against the customary court.
customary code.
And if
So he should himself continue with whatever is available in
Exactly.
the court,
exactly.
or he should uphold that.
Yes.
Got it.
And my lord would kindly appreciate one more thing. Page 23, your lordship will find who were the appellants before the court. My lord
Only,
finds only one.
one.
Now,
And
my lord,
they have
now my lord will find the page 65, the plaintiff. Plaintiff to page 66, my lord will find the names of the plaintiffs.
This is the appeal title suit preferred after the
After
order.
as per the liberty.
How can they go beyond that?
Cannot go. And this is a suit by two new plaintiffs and new defendants against new defendants.
Yes.
To extend of my lord, definition of de novo under this section 15, I also consider some this requires some interpretation by this honorable court, my lord. Now,
You tell me the facts, thereafter the interpretation. will
yes,
come.
my lord. Page about my lord, I will directly start with my lord kindly at page number
I'll
91,
not
my lord.
venture into areas which I'm not required to go into.
Oh, yes, my lord.
You counter his arguments.
Page number 91, my lord, you would be relevant, my
Tell
lord.
me first thing, one thing.
My lord.
I had my doubts against it. That non-existing 13.8. It's non-existent. Mere certification, whether that would be, and that too, for proceeding before the larger body.
My lord.
Now, he satisfies me that with your thing, that only a pronouncement is required. Now, that pronouncement is proper in presence of parties and in presence of independent witness. Those are the three requirements. That you can challenge. You have already challenged in that appeal. Right? Appeal, no further evidence can be taken. Right? So if no further evidence can be taken, the court can use the power, second part of the Civil Court Act, and convert it into a suit and proceed. Take evidences, come to a conclusion, end the matter. Now, here, the appeal was filed by one man. Right? Now, the court does not give him, he cannot impede petitioners other than who are already there. Respondents, with the permission of the court, you can go on.
Yes.
Or you can be an intervener. But the liberty that has been given to you, this liberty literally you have now filed the suit. It's before the district judge itself.
District judge itself.
Before the district judge. Where is that power given under the act? That you can file a new plaint. Filing a new plaint, presentation of a new plaint would mean a totally new proceeding, got nothing to do with this one. It is this proceeding which he should have carried forward. You could have made an amendment. You could have brought in a challenge to that initial Gaon thing.
Lord, that's why I started my Lord submission. The meaning of the definition about de novo under this act. That maybe requires some.
This de novo should be understood in the provisions of this customary law thing. No, Civil Code Act.
Civil Code.
To come to the Civil Code Act, proceed with the case de novo.
De novo
means he will feel that the orders under appeal are not there.
Not there.
He will go to the issue directly.
Exactly.
That was the only doubt I had. And he has now misled me to that extent. Now you clarify. He misled me. He is known to that. You clarify.
That extent,
otherwise that misleading will come in my order. It's very bad.
That's why, my Lord, I started submission, my Lord. This word de novo, my Lord, in context of this civil code, my Lord, I humbly also understand feel that requires some definition by this honorable court, my Lord. Where, my Lord will, my Lord, no, my Lord, in village level, my Lord, there is no such plain or written statement, my Lord. File, my Lord. No, now if de novo trial start, my Lord. De novo trial, in absence of those, my Lord, list of witness, plain, my Lord, and written statement, my Lord. From where, my Lord, this de novo trial, my Lord, could be start, my Lord. That is the issue, my Lord, need to be addressed, my Lord.
You address?
My Lord. My humble understanding, my Lord, I tried, my Lord, the de novo, when I tried in term of, my Lord,
de novo, you will get it. De novo means a new.
Start
a new.
New, my Lord.
Means a new. 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 You can start it new. But that meaning has to be understood in the context from where it is emanating. It is emanating from your Civil Codes Act.
My Lord.
Here, the power is the customary court's order will be before the district judge.
My Lord.
He can uphold that.
My Lord.
Or if he does not feel that that is proper,
my Lord.
He can ask, say the wording is proceed with the case de novo.
My Lord.
That means whatever is there with him, he will ignore the, what do you call that, decisions, which is under challenge of the Kebang. If I'm a Kebang or that village authority, that decision he will ignore. He will go by the issue. And then, because now he is empowered to take witnesses, evidences, which he is not there normally when it is under appeal. Appeal also he can take. There is no bar. CPC provides for that. But there is a procedure for that. But here, it's just a decision of a quasi-judicial body.
No, my Lord,
it cannot, the court cannot remand back the matter to that body to take evidence. If it is an appeal, first appeal or something, some points are there, it can note it and it can require either take it himself, there is a provision I suppose somewhere, or it can give it back to the trial court to have that evidences on that point taken and then decide the issue in the appellate court.
My Lord.
Where is that provision in the CPC?
My Lord.
CPC, where is that provision?
Provision as to
the evidence in appeal.
Yes, Order 41, Rule 27.
Order 41.
That's an additional evidence in an appeal.
No, just Order 47.
Order 41, Rule 27.
Wait. These are new things for me. Let me also be a little bit slow.
My Lord.
Order 41, Rule
27. My Lord. Production of additional evidence in appellate court. Order 41, Rule 27.
Or any other subordinate court to take 28.
28.
To take send it to it when the appellate court.
Yes.
So here, I'm just
Here,
trying to understand this proviso.
May I just clarify?
Hmm.
Here, the provision is little bit peculiar in terms of, because it's a appeal which is arising out of a customary court, which is not a civil, though it has been conferred the
Conferred
power
with-
of
not
a
a
civil
civil
court, but that's not a civil proceeding as prescribed by the CPC. Therefore, my lord, the moment the district judge feels, my lord, that the order that is being passed by the customary court is non-est.
I'll not call it order, the decision.
The decision is non-est.
Non-est.
Therefore, now the issue which has been raised has to be decided by the court, the district judge, as there is nothing proceeding, no proceeding was
Is
there.
there.
It is a new proceeding. As your lordship very rightly pointed out that. In fact, the appeal, their plea was that I have a right over this land. These are we are the person who have encroached. In the written objection, we disputed that. We said no. It
That
was
is
already,
fine.
it is my ancestral land.
Some cousins or something.
Yes, yes, it is
relationship
my
there.
ancestral. Now the issue of fact which has arisen before the learned district
That
judge
has to be
is
decided.
right title interest over that
Plot of
particular
land.
plot of land. That
He does not have that power to return the plain, asking a fresh plain to be filed
exactly,
before a particular court.
my lord.
Then, if that would be so, you cannot come back to the district judge because that suit may be valued or that property would be before a junior civil judge.
Yes, it may be before the munsif.
Munsif also.
That way, my lord,
And that way we lose one forum of the appeal.
that,
He should have straight away dismissed this,
my lord.
saying, leaving it open to you to claim your right.
Possibly, I would have no ground to challenge.
Ground challenge that. But again, can he do that?
Given
the words of civil court.
My
Act?
lord.
Yes, he can.
May dispose of the same.
May dispose of the same.
That means he
Means
can
either
pass-
uphold the order of the customary court or proceed, or it's a or. So, or proceed with the case de novo.
So he can dispose of the case asking you to institute a civil proceeding under 9.
No. What I understand, subject to correction. The dispose of the same means in a appeal, as it is an appeal, though the district judge will exercise his powers that is conferred as an appellate court, and on the basis of the materials that is available on record, either will uphold the decision of the customary court, and if the district judge appeals the decision of the end of the matter, if the district judge finds that the order that is passed by the decision of the customary court is erroneous, and then the second portion will come or proceed with the case de novo.
Okay.
He will freshly adjudicate on the issue.
Yes, my lord.
And if the district judge, in my respectful submission, the district judge interfering with that order to that extent also could have been understood, because the district judge ultimately has decided to proceed with de novo. So this decision would not come in the way.
Yes.
Yes, ma'am. Now, that way, my lord, de novo, when by impunity, my lord, he decided, learned district court decided to start a case de novo, my lord. Now, that way, my lord, the situation before the district court, my lord, to start a case de novo, my lord, my humble understanding, it is require plain, my lord, written statement, my lord, and the issues, my lord.
That's why.
I
told you, he's misleading me. You established that this word de novo would require a filing of a plaint,
my lord,
a filing of a written statement,
my lord,
determination of issues,
my lord,
evidence,
my lord,
suit, judgment, degree. That this is the procedure to be followed, or as he is trying to make out, the appeal that was there. Now this appeal, the court will decide the original issue, not the issue under, not the order under appeal.
Right.
It will go to the original issue.
Yes, sir.
Now, once it goes to the original issue for determination of that, it will have the power to take evidence because the court below, if I may use that word, court below, there was no procedure for it.
Right.
Even the decree of a court or a judgment of the court, it's defined in the, that's why I was trying to ask him in the CPC, that it should be a written reason why. Here, that is not called. So there is no material for the court to rely upon. Right? Now you tell me, if that be the situation, how can a fresh claim be filed? And that too, with a totally separate cause of action. Why I say so? Two plaintiffs are coming. Addition of defendants, which is not there in the appeal.
Well, to that extent, partially, my lord, I would clarify if this order, my lord, is interpreted in such a way that if they are allowed to file the claim, my lord, I have no objection, my lord. Even if they are allowed to file the claim, I have no objection, my lord.
No,
Now,
we will not. We will only interfere this order if so required to the extent of the last part.
Yes.
As a result, I will not even interfere with the
Yes. sir.
penultimate paragraph.
Yes.
Because he is now deciding the issue.
Yes.
Status quo will be maintained, subject to further orders.
Yes. And the district judge will
Decide.
adjudicate the entire issue.
no, my lord,
Any decision on this proviso?
No, I did not find it, my lord.
I was also looking for
I
it,
was
did
also
not-
looking for
did not hear it.
yes, my lord. That's why I said they require some interpretation by this provision, my lord. Now, situation before the land at district court, my lord, would be, my lord, if suppose, my lord, de novo trial start, my lord. From where, my lord? There should be some material to be start de novo, my lord.
Sir, that's what I'm trying to tell you. You
No,
interpret this provisional.
My
I
understanding.
told you, I'm again repeating. It's all online. You again repeating. He is misleading me. You clarify. You bring me to the track.
Now, as per my lord, definition of my lord, this Blake Law Dictionary, my lord, in terms of trial de novo, my lord. Trial de novo means, my lord, a new trial on the inter case, my lord. That is on both
Mr. Counsel, there is no doubt on this. No dispute on this.
In fact, I am with him for this. Let the new trial begin.
Yes, my lord.
We are adhering with you that there has to be a new trial. The
Yes.
only question is whether that would require the filing of a plaint, and that too, or only on the appeal and the written statement, issues are framed and thereafter determined. If you want to examine, you can examine. I'm not rushed because my order will have some consequences.
My lord.
I can have it.
No, my lord.
He has made his submissions.
My lord. Now that part, my lord.
You examine, no problem. I can give you a day or two, no problem. I'm here.
My lord, I also feel that, my lord, this de novo, my lord, requires some interpretation. This now, my lord.
Assist this court, bring on record materials.
My lord, to that extent, my lord, as this, my lord, I am also not get anything on the interpretation of de novo, my lord.
No, de novo, you forget it. You interpret the proviso to your Civil Code Act 2020.
In terms of civil courts, I have not got any material, my lord. But my lord, kindly appreciate the.
What will I appreciate on? You are not putting me any material. If I appreciate on his, the fate is sealed.
No, my lord. About the fake, my lord, I have other submission, my lord. About the fake,
Come.
Page number 91, my lord, will kindly turn, my lord. Page number 91, my lord. My lord. Now, my lord, they are projecting a case, my lord, saying that, my lord, there was a decision by the lease village, my lord, authority, my lord. Now, when that was not, my lord, this.
We say this is wrong. We are interfering with this. And we will uphold the interference made with this by the impute order. I'm only, if you come to page 64.
$64, my lord.
The last paragraph.
My lord.
If your appeal petition is defective,
My lord.
no further proceeding is called for it.
No, my lord,
Only thing you can do is amend it.
no, my humble,
See, basically, he is, that appeal before him
my lord.
under this provision is not there. Gone. That is not provided for. Mr. Kaushik, when are you coming back? We'll give him some time. When are you coming back?
29th February.
29th, fine. You prepare. I also get some time to prepare.
I'll also try.
Otherwise, he might. Understood something, let's see.
Otherwise, my lord, the provision of section 26.
Yesterday night,
CPC.
I was totally against it.
Yes. My lord.
But now you have given a line of thought.
In fact, my lord,
Welcome the word.
the district just interfering with the entire issue. It was correct.
I'm telling you, I
In
will
fact,
not touch.
To be
the
fair enough, my
penultimate-
lord, it is correct.
I will not touch with the penultimate
Right.
paragraph. It is only the paragraph, the last
Right.
paragraph that has to be
And
inserted.
because of this, my
And
lord,
if the Learned Council can show me that interference with that situation, the direction to file a fresh claim is permissible.
Permissible.
That is the end of the
that is
matter. Because the procedure, one more
my
doubt.
my lord,
May the word used is
may dispose of the appeal or proceed with the case deed.
or proceed with the case de novo.
De novo.
Now, this is a gray area.
This
It's
is
a very wide area.
yes.
Now, merely by requiring him to file a plaint, whether prejudice is caused to you,
Yes, my lord.
whether prejudice is caused to you, that plaint is wrong. He could not have brought in additional parties. He should have limited it to what was there. Thereafter, use the CPC to get whatever he
My
could have done.
my lord,
But if that is permissible,
my lord.
to that extent, so that the issues are finally decided.
It prejudiced me because, my lord, now the district judge, while exercising a power
No,
under
he
the appeal,
continues to exercise if we hold. In this situation also, he continues to hold. It will not be a title suit. It will be that appeal only. But he continues to hold the, we declare that this provision, this proceeding, de novo, is not a proceeding under the, it cannot be deemed to be a section 9 institution of a proceeding.
section 26.
26 cannot be 26. It would continue to be under the proviso to this. No prejudice is
In
caused.
that scenario also, now this suit originally would have lied before the, in terms of
Munsif.
the jurisdiction, munsif or civil judge.
But
It-
it having, and you having come through the customary court,
Yes,
you having gone to the customary court, and this being an appealing is that.
exactly.
And the just
My lord,
try to-
yes, my lord.
and the
I'll-
district judge, for fairness, to come to a correct conclusion, had resorted to this manner. We are not saying that the plaint is proper. We are not saying just the direction of the learned district judge that you file a plaint. Plaint, not in the sense you understood in the normal parlance.
My lord, I think it cannot be. District judge doesn't have the power to do so.
You mean to say that he'll have to continue with the appeal as a
Yes,
plaint?
as a plaint. As a plaint, now this proviso makes a very peculiar situation. Because it's a state act which has brought in and given comforts have some power to the district judge to exercise this jurisdiction in an appeal
Of the deputy commissioner.
of the deputy commissioner. So earlier what this proviso was not there. Where the deputy commissioner passes an order, we used to challenge that order in a revision petition.
Here.
Yes, because there is no provision of second appeal.
So, that is, it cannot be.
Cannot be.
That is because the district judge was equated with that of a deputy commissioner.
Hello. Now, if it is treated to be a new title suit, then it's a degree of
changes.
a original code. Then Order 41 provides a power for first appeal and Section 100 second appeal.
First appeal before the senior judge, second appeal before the
Second appeal before the High Court.
High Court.
High Court. Now, here is the position. Here, if the court decides it,
You
it
have
is
come here on first appeal.
either first appeal or a revision
Revision
petition.
petition.
Because these Arunachal Civil Code Act or the Assam Frontier Regulation 1945 does not provide any power for second appeal. There is only one appeal.
Now, why was this Civil Code Act required here?
Because initially
Act
there was
required here. There has to be some purpose.
some part. The preamble says to consolidate the law relating to civil codes and for establishment of various civil codes for speedy disposal of civil cases of state of Arunachal Pradesh and matters connected therewith and incidental thereto, be it enacted by the legislative of the state of Arunachal Pradesh in every second year of Republic of India as follows. Possibly,
Come to 2B.
2B, yes, civil code definition of civil code. Means a court of district judge, a court of an additional district judge, a court of a civil judge senior division, a court of a civil judge junior division, and or a customary court, including the village authorities.
So that is also a civil code.
That is also a civil code.
So that is Munsif.
Munsif. Because of this, the Assam Frontier Regulation
If that is a Munsif, in this, if that is a Munsif, then only an appeal will lie before the district judge.
And that first appeal.
First appeal will.
First appeal. And in fact, that appeal memo, if your lordship will find it's an order 41. It's an appeal, first appeal.
First appeal. Okay, 29. Try to throw some light. Otherwise, he's done it. Heard the parties at length. List this matter again on 29/1/2024. 29/2/2024 for further hearing. You give me a written.
I'll give it.
Before that.
My lord, I'll
Both of you. Whatever you get it.
My lord. 16, my lord, it's an appeal against the rejection of an injunction law. My lord,
the respondents have all appeared.
They have all appeared. My lord, before if I start, my lord, I'll just make one prayer, my lord, here. In respect of whether granting and refusal of the injunction, my lord may not.
No, that is not an appealable of down that decision. You are against an order of non-grant of injunction.
Yes. It's order 43, rule 1R. There is a provision for appeal. Well, CPC.
Okay. Non-grant of.
Non-grant.
Non-grant is appealable. Yes. The other one means.
Even I grant for grant.
You file an application. Therein the Supreme Court has recently said the other way around. Which is the one? Order?
Order 43. Rule. 1R. Any order, my lord. So, to my understanding, my lord, even if injunction is granted, then also appeal will lie.
No. There is a 30 days time. Where is it given that you have to decide it within 30 days? Say injunction is granted.
Injunction.
Then a vacation is filed.
Yes.
Or what do you call that? Objection is filed. That has to be decided within 30 days.
Yes.
Against that.
Against that, possibly.
Against that, an appeal lies, but a revision will not lie.
Revision.
I think to that extent, they were done. Here, what do you want to show? Any order?
My lord, yes. An order under Rule 1, Rule 2, or Rule 4, or Rule 10 of Order 39. Order 39. Any order that is passed under this
order
rule.
Under Rule 1, 2, order, so and so, so and so, so and so. An order under Rule 1. Rule 2, Rule 2A, Rule 4, and Rule 10. Okay.
No,
yes, you are paying for the
respondent, my lord.
What do you have to say?
Our affidavit is ready, but we could not file. We could not file affidavit.
In fact,
it is already on record.
Yes, and more importantly, my lord, to the extent of conceding to the prayer of injunction and or my lord, I would concede because lordship can remand it back to the authority, the civil judge, to decide the question of injunction. Why I am before your lordship is my injunction was rejected only on the ground that the civil court do not have jurisdiction. I'll have to take a clarification from your lordship that the civil court has a jurisdiction because it's a suit under section 6.
Basically, it was a case of eviction by the estate officer.
No, that is what the
starting point.
Malab, we filed a civil suit under section 6 of the specific relief. Lordship knows that section 6, the ambit is very less. And this suit is against 2 private individuals. I say that I have been possessing since this land since a time immemorial and I have applied for some settlement. Now, I have been dispossessed from that land. He claims that no, I am in possession. I have also filed some application for settlement. Now it's a dispute between us. As this land has not been settled between both of us. Therefore, we don't have right title interest over that land. It is as on today a government land. So we filed an application under section 6 where the ambit of the court is that whether the person has been illegally dispossessed and the suit has been filed within a period of 6 months of disposition. That is the 2 issue. There are judgments of the Honorable Apex Court that in a section 6 application, court cannot go into the right title and interest. Now, there was some proceeding which was initiated by the estate officer against him. So-called notice and all. Now, the learned civil judge drawn a corollary from that act saying that saying that there is a provision in that act which excludes the jurisdiction of a civil court and therefore the civil court will have no jurisdiction.
Public premises eviction.
Yes. Now, public premises, the exclusion clause in the Public Premises Act, it clearly says any order that is passed under section 5, 6, 7 and 8 of that act, no cognizance of a civil court can be taken. So it has to be understood that if an order that is passed by an estate officer is put to challenge in a civil court, then there is an exclusion of the civil court jurisdiction. Now, this is a case where it is a dispute between us. It's a private dispute where the estate officer doesn't come in because that act, Public Premises Act, it provides that the estate officer, if upon satisfaction finds that somebody is illegally occupying a government land, he can proceed in the manner that is prescribed under the act. Now, if the manner which is being prescribed, if somebody is aggrieved by that manner, that cannot be questioned in a civil. Here is a case, I am not aggrieved by any action of the estate officer. I am before the court under a section 6 application saying that this person, he has dispossessed me illegally forcefully. And therefore, civil court order will have jurisdiction.
In fact, if we understand it in different way,
my lord,
to which person the court, the estate officer will issue a notice, is the issue arising in this?
No, that is not.
Otherwise,
yes. And therefore, my lord, otherwise, my lord, the learned civil judge.
See, government land. Government has the power to evict.
Yes.
Now it has to evict you or evict him. That is the issue.
That is the issue. And that would have been if the government would have taken any action against me or I would have challenged that action in the civil court.
Then bar would.
That bar would come.
It's only after the estate officer's order in under that provisions of act, you can file an appeal before the district judge.
My lord. And my lord, now what the learned civil judge, while rejecting my injunction application, has observed that I had a good case for injunction, but as there is a bar under this bar of civil court jurisdiction, and therefore the injunction has been refused.
Yes. We can remand this back to back.
Yes. And my lord will just clarify that position because my civil suit, the question regarding maintainability of the civil suit is also pending. Now, the learned civil judge is waiting for the decision of this court. The learned civil judge wants an...
What do you want to? We want to file something?
Yeah, my lord, affidavit is ready now. Then due to this respondent had some pertaining
you file it by 23rd.
Yes, my lord.
File it by 23rd, 29th.
29th.
We'll have it on 29th.
Okay.
On the prayer of Mr.
M. Lego.
Huh?
M. Lego.
M. Lego, Learned Counsel for the respondent, lists this matter again on 29/2/2024. The respondent is permitted to bring on record his pleadings on or before 23 23 or 27 to 2029, 2024. Also. Heard Mr. BK, also heard Mr. BK question, Mr. B. Kaushik Leonard, counsel appearing for the petitioner is present.
Hello. Madam will kindly observe one thing, Malord. The matter will be taken up for final hearing on 29th. Because the matter is pending before the civil judge on 23rd, Malord. I can have
this court would, an endeavor would be made to dispose of the entire, it's an
FAO, Malord.
FA, the entire FAO on the next date of hearing. Now, why is it come for orders? We can have it for admissions.
Yes, yes, Malord can
Huh?
have it for admission.
It's not admitted.
Yes.
Next date में लिख दीजिए. List this matter again. Now, there is an order of status quo of the suit.
There is this on this too.
So how can the issue before the learned single trial court be decided?
No.
Oh, it's not, it's only on the land.
Only on the land.
The extent of his can't do it.
Yes.
List this
And
matter
in fact, Malord,
for admissions.
I was just trying to explore this, Malord, that even if a declaration of possession or disposition, if it's given by the learned civil judge in respect of either of us, that declaration would not be binding upon the government. Because that is only in respect of this.
That's why I said the suit is the government will issue a notice to you,
yes,
or to him,
or to us.
The power to issue notice cannot be taken away.
Cannot be taken away by this proceeding.
And that I will make it specific.
Yes, in fact. Malad, in fact, that was the thing which was there in the learned civil judge's mind.
Maybe.
My lord, extremely sorry for problem. Item number 19.
Oblige, great.
I have some medical emergency.
Please.
In item 19,
Yes, sir.
only a notice has to be affected to the victim.
Huh.
A notice has been served.
Sir.
And the victim, counsel for the victim is appearing today.
Okay. So we'll have it on a date whenever it's convenient to you three.
Yes, my lord.
When is it convenient?
After 2 weeks, my lord.
List this matter, item number 19, on the prayer of all the parties. List this matter again on after 2 weeks on a date to be fixed by the registry.
Appearance of the counsel for the victim.
Mr. R. Quim, learned counsel appears for the respondent number 2. No. Respondent 2. Respondent number 2. Okay.
For admission.
For admission. Now admissions. For admissions.
Deeply obliged.
My lord, this matter is otherwise ready, my lord, for hearing. This can be disposed of, my lord.
Previous to couple of occasions, it was fixed for order.
Wrongly
Though with the counsel mentioned it, to list it in the admission hearing. So this time also, my lordship, the case is listed once again by mistake in the state of order.
Yes, what is the thing?
So I'm petitioner, Your Honor. Here are the some point. My lord, here are some point I'm submitting in favor of my case. May I, my lord?
When was this proceedings instituted initially?
Initially, it was.
How did it reach the deputy commissioner from the village courts? Or directly?
No, not the village court. Initially, the case was launched. It was decided under 154, under 145 CRPC by executive magistrate. Then aggrieved with that order, respondent here respondent number 4 of the case, appeal it to deputy commissioner. Deputy commissioner should not have interfered. The judgment.
It's
of-
okay, we had a, because I saw the same names again.
Yes, yes.
So I said, it's okay, it's a different FIR altogether.
Explain also.
Hmm.
I was told, instructed that a subsequent FIR also been filed.
Hmm.
But I did not know that they had, and just someone had counsel has filed that, I did not know. So otherwise I would have- Only in the morning
No, it's okay, because when I saw, that's why I said, I was about to dictate, then I saw these cases. Now she has, I did not see the brief. So then Ginny has, T. Ginny, your counsel has clarified that, sir, this is two different FIRs. No problem.
In fact, I checked the brief also.
It's
I also
different.
got one.
It's different.
Then the order will stand.
The orders will stand. I'll dictate it.
So
Okay.
in the brief, my lord may submit. In the brief, my case is very easy and very short. Precisely, my lord.
Your
And
case is
between-
easy and short, provided Mr. Sunar is not there.
Well, here,
He will be submitted
issue of
very precisely. I hope.
maintainability of 482 is also there. Because my lord knows, because now 482 application has been preferred against the order passed in the revisional jurisdiction under 397 by this session court. So for whether my lord under 482, second revision petition can be maintainable. Law says my lord maintainable, but there is a but my lord, sparingly and in a very rare case where there is a my lord.
Okay. When do you want it for admissions?
My lord, is it possible? It will be hard to today,
Today,
since
no.
all the councils are present.
My lord, issue involved here is only my lord thing. Otherwise, my lord, very limited issue, my lord. That only the issue that the learned trial court has said, my lord, only because wrong section has been quoted in the order, but the power has not been accessed. by-
For remand, we'll have to basically finally remand it.
No, my lord. Now, my lord, what is being impugned in the order is only that the order passed by the learned deputy commissioner, my lord, is like in the order sheet, it has been wrongly typed as section 145. But, my lord, the entire power has been not exercised under the CRPC, but the power has been exercised under the statutory power under the Arunachal Pradesh Land Record and Settlement Act, my lord. And this particular finding.
Take me to that order of the deputy commissioner.
My lord, I will.
Counsel, just let me get through it.
My lord. The order is, my lord, order impugned, my lord. You will find at page number 45 of the petition, my lord.
Page 45 to 49. I have annexed it as annexure 8.
Yes, I got it.
Yes.
Some facts, my lord, before this, my lord, some short
Just
facts.
then what happened? He went before the session judge.
My lord, he challenged this saying, my lord, before the session court, my lord. Then the ground of challenge before the session court is that no, since already 145 proceeding decision has already been issued in his favor, there is no dispute, my lord, in the earlier occasion. Now, the case before the session court was whether because in the impugned order, only because order 145 has been quoted, but the power has not been exercised under 145. Power has been exercised.
Have you taken the specific point
Yes,
before
yes,
the
my lord, my lord, some facts, my lord, before.
No. Just I'll hear him first.
Yes.
But just asking him.
Yes,
because
yes,
you
my
are
lord.
the initiator.
Yes, my lord.
Then what happened?
My lord, then
Then
my
it
lord,
comes before the session court.
session court and session court's impugned judgment, my lord. Let's see the impugned judgment, my lord. Especially, my lord, will see page number 88. Page number 88, contention, my lord. Before the commission, thereafter, my lord, let's come to page number 90. Para 13.
Okay, para 10 is your objection. Page 89.
Yes, my objection, my lord. My objection that there is no information sojourn under the jurisdiction of Arunachal Pradesh Land Settlement Record and so, my lord. my lord, this para 13, my lord. As observed above, having agreed by the decision dated past with the present OP had preferred an appeal before the Commissioner of Land Management Government of Arunachal Pradesh under Section 83(1) of the Arunachal Pradesh Land Settlement and Record Act, so and so, so and so and so. The Commissioner had remanded a case back to DC for holding fresh hearing, consequent upon which the impugn order was paused, and after hearing both the disputing party, learned DC had exercised the jurisdiction under Section 12 so and so of the land. Thus, the DC acted as the collector of his revenue jurisdiction, not as the magistrate under the code. And actually, so is the copy of the impugn order and its heading
got it.
is order. So this is not the order, my lord, passed under CRPC. My lord, not the law says, my lord, reflection of the recording of the wrong section
Will not.
doesn't matter. Only this, we have to show, my lord, that the deputy commissioner has a statutory power to exercise the power. That, my lord, 145 decision under 145 by the executive is in his favor. My case is like that, my lord, because this is a government land, my lord. Admittedly, this is a government land, my lord. He procured, the petitioner procured 600 square meter of land allotment. So, when I came to know this, the 600 square of land allotment was procured, I filed a complaint under the, now my lord will see, Arunachal Pradesh Land Record and Settlement Act. It's a statutory act which governs comprehensively how the land allotment is to be given, how cancellation is to be done. I invoke the power of the deputy commissioner under Section 9 of the Land Settlement and Record Act. I filed a complaint. Then they want the deputy commissioner got himself confused, saying that he thought that 145 proceeding, while exercising 145 proceeding and exercising the power under Land Record Act, he is the same person, the first deputy commissioner. Then what he did is like, since I have already decided under 145, I will not decide under the Land Record and Settlement Act. But my lord knows these two acts are completely different. 145.
Then the matter goes up before the director of
Then
land.
I said I filed because there is a remedy for the statutory appeal. I went to the commissioner.
83.
I said that, see, deputy commissioner has declined to exercise his statutory jurisdiction. And then the commissioner said, okay, you have to hear both the parties. Then hearing took place. The petitioner was also present. Then the deputy commissioner came to the conclusion, no, 600 you have illegally obtained. You are entitled only for 400 square.
So 200 was kept with the government.
With the government, not given to me also, because this is a government land. Now, against that order, he filed a revision petition. Then maintainability of the revision petition came. How criminal revision petition will be maintainable against the order passed under the statutory act, under the Arunachal Pradesh Land Record and Settlement? Because the criminal revision will be maintainable only against the order passed under the CRPC. Then at the most, the remedy was with him is to file the writ or file the appeal, because there is again statutory provision to file the appeal against the order of the deputy commissioner, that is the commissioner land. So instead of that one, only taking of the cue from, because section 145 is reflected in the order. So that's why then the learned session judge has dismissed the revision petition, saying that not maintainable because deputy commissioner has not exercised the power under the CRPC, but it was a statutory power under the Land Record and Settlement Act. Therefore, my lord, now interestingly, 482 section, 482 criminal petition has been filed before this. Now, my lord, issues before my lord is that, first, my lord, whether this is a fit case where 482 power should be exercised, my lord, to.
Okay, fine. Got it.
My lord.
Yes, petition.
He has made submission on his part.
The first,
My lord.
take
Yes,
me
yes.
to the facts. Initial facts.
Yes. Very short. In a very short, my case is. My question, my case is comprised of 4 issues only, my lord. Yes. Can a deputy commissioner override the judgment of an executive court which is passed under 145 CRPC?
145 CRPC will be with regard to.
Yes. It was passed in favor of me, my lord.
Where is that order?
It is. I have annexed it in order. Yes, page 31, 30 and 31, as annexed 4, my lord.
Mr. Sonar, your client's name is?
My client name is Hage Appa, my lord. I am the respondent number four, my lord.
Sri Hage Doilang Appa.
Yes, my lord, yes.
Just come to page 24, Mr. Counsel. That land allotment order, 600 square meters.
Yes, I'm there, my lord.
So this is the starting point. Hmm? Then what happened?
Then agreed by the order under 145 CRPC. This respondent number 4 made a complaint to Deputy Commissioner, which my learned friend Mr. Sonar has submitted that this complaint was filed under law of AP Land Settlement and Record Act, but it was nowhere mentioned either in the complaint letter or in the order of the learned Deputy Commissioner that the application was filed under the AP Land Settlement and Record Act 2000. Then this complaint letter of the respondent number 4 is at 32 to 42. Subject, in the subject itself, my lord, 32. Revocation of land allotment. Number DC ICC 12 to 2002 219 dated 14/5/2019 issued in favor of Srimati Landiappa. Landiappa means me, my. So in entire body of the application, even in the prior portion, my lord, there is not a single word mentioning that this application of complaint has been filed under AP Land Settlement and Record Act. My lord, my submission, whichever cannot be done directly, it cannot be, it cannot either be done indirectly. Yes, my lord.
Mr. Counsel, show me the reference here to that 145 order in page 32 onwards. Where is Mr. Sonar's client referring to that 145 order and making submissions on that here?
Page 45.
Page 41.
Page 45 to 49. The impugned order passed by Deputy Commissioner, Capital Complex.
No, not of that.
Yeah.
This order at page 32 is subsequent to the order passed under 145?
Yes, yes.
So this is not an order. This is not an application challenging or dealing with that 145. Yes. It's with that allotment letter. Here the allotment is being questioned, land allotment. 600
Yeah.
square foot. That is being questioned here. Now, where is the order?
Order 45 to 49. Page 45, my lord.
So the order is at page 43, first order, Deputy Commissioner, asking the petitioner to proceed with the work because your case has got no merit. No documents were there.
No, my lord, this particular 43 order,
In 43, huh?
43 order, my lord, what happened? 145 has been already decided in his favor. I am not concerning, I am not challenging even. Let it be there. Then, my lord, I filed for revocation of the land, and my lord has rightly pointed out. Then Deputy Commissioner passes section 43 saying, since 145 already decided.
Where does he say?
Section 4, page 43, my lord.
After perusal and view of the report of the so-and-so as per
Record passed by the ESC Executive Magistrate. Against this order, my lord, I have to go to the Commissioner.
83 1B.
My lord, my lord. Then matter again remanded back to Deputy Commissioner. Then Deputy Commissioner has passed the order, my lord, cancelling his 200 square meter of land. Still, my lord, 145 is in his favor. I have nothing to cancel, my lord. It's only about cancellation of the land allotment. Now, my learned friend is trying to mix up both the things, saying that I have challenged the 145 order. It's not my case.
No, this report of 2010 is that 145 report. Or there is some other report?
No, no, my lord. It has no connection at all to the case. And it is not the event, it is not even the record of the Deputy Commissioner.
You can come to page 49, the order.
I'm there.
No, this one, page 49.
Page 49 of the
It's a
petition.
part of that 2210.
Yes.
On the basis of the report of 2010. Now, what is this report of 2010? Yes,
My
Mr.
lord, here what happened, during my lord examination, during hearing, my lord, then the Deputy Commissioner came to certain records, whereby it was said that originally the petitioner had applied for only 400 square meters. Then wrongly, but allotted 600. That's why he relied, because these are the official record.
So, 200 kept back.
200 came back, 400 given to them.
And you have no dispute on that.
No, my lord, I cannot, my lord. Only now the issue is only, my lord, limited issue, my lord. The jurisdiction was involved.
Okay.
In challenging this law.
Okay.
The only contention was that the proceeding was initiated under section 145, which has been not accepted by the learned the session court, saying criminal revision cannot be maintainable against the order passed under the statutory act under Arunachal Pradesh Land Record and Settlement Act.
Okay, now,
This is
now,
the case.
now, counsel, just take me to that order of the session court at page 86.
36. I'm there, your lordship.
Yes. Now you make your submissions.
Yes.
This is the only issue.
My lord, only
Yes,
the
yes,
issue.
yes.
Otherwise, my lord, not maintainable. I will show some judgment, my lord. 482 cannot be a second revision.
No need to go to that question.
No,
When they verify.
Otherwise, on merit also we can.
Criminal proceeding not, he'll have to satisfy me
Satisfy.
that this is a proceeding. We may go into that. We have the power. Second revision in a case can be maintainable.
Maintainable.
But if the ingredients. are there. But here, that question will be second. First question would be whether the proceeding that is initiated before the sections court was in fact maintainable. If it is maintainable, then only the question whether this revision would be maintained.
Yes.
If we hold that the proceedings were not under the criminal code of procedure, but under the revenue act, so the order of the session court must be upheld.
Yes, ma'am. Yes.
He will have his remedies, whatever he.
Yes, yes. Appeal authority, writ petition, plenty of remedy are there.
Yes.
Yes. So, it seems my lordship has understood the verification.
I'm just trying to take the feel of
certain, certain extension in very precise, I would like to make, Your Honor. I'm petitioner. My case is comprised of only 4 issues, Your Lordship. That is, how, under what authority deputy commissioner had override the judgment of the executive minister passed under 145 CRPC. 2. Can a deputy commissioner decide a title of a land under this litigation as he done in my case? 3. Is a director of land management or deputy commissioner an appellate authority under section 83 of Arunachal Pradesh Land Settlement and Record Act 2000? My learned friend, Mr. Sona, is referring here. As he acted in my case as appellate authority, both director of land management and deputy commissioner. 4. Can a case initially, can be a case initially initiated under criminal court, under criminal law, can be a matter for a revenue court or revenue authority under revenue law, that is of Arunachal Pradesh Land Settlement and Land Settlement and Record Act. My lord, I have an allotted land. I have an allotted land measuring 600 square meter at each sector. So private respondent number 4 filed an FIR alleging me as a trespasser and claiming my land to be his land, which was already allotted to me in the year 2019 by deputy commissioner himself, who had passed subsequent order, which I have made before, led before your lordship as impugn order. Then after getting FIR, police had very correctly, my lord, forwarded it to the Honorable Court of Executive Magistrate Itanagar to try under 145 CRPC as the matter involved land which was already allotted by the allotment authority. Then Executive Magistrate passed the order in favor of me because it was already allotted in the 2019. And as my learned friend Mr. Sonar had referred, that the revenue survey record of 2010, I was not given allotment in the year 2010. I was given allotment in the year 2019. A lot of extension, after lot of extension, after lot of more occupation of land, partly by buying, partly by occupation of no man's land. This was how that 2010 400 square meter has turned into 600 square meter in the year 2019. And my lordship then agreed by this executive magistrate order indirectly. Respondent number 4, private respondent, sole private respondent 4, had filed a complaint against me for cancellation of allotment order. So what cannot be done directly cannot also be done indirectly, my lord. Okay, my submission. The learned deputy commissioner had dismissed that complaint because it was already decided in the Honorable Court of Executive Magistrate under 145, and after verification by Land Management Department, it was found that the allotment was genuinely given to me in the year 2019. So agreed by this order again. Then this respondent number 4 made an appeal to the Commissioner Land Settlement under section 83(1) of Arunachal Pradesh Land Settlement Record Act 2000. Then, whereas Your Honor, this section, this section 83(1)(b) of Arunachal Pradesh Land Settlement Act says that when any original order is passed under this act, then only appeal can be made. AP code, yes. I'm reading 83. Though it was not reflected in any of their document.
Section
Yes,
83?
yes, section 83(1), which has
Act,
been
Act. The rule, volume 7.
volume 7.
I'm sorry, I was asking certain questions just to get the hang of the things. That's all.
Page number, it starts from 200.
It was very academical.
Huh?
My lord,
Page-
it is very academical with you.
Yes, page.
Yes,
Page
this
starts from
page
202, my lord.
227 in my
It starts from
book.
202.
You want section 83.
Section
The rule is
83.
section
No,
Section 83.
Hmm.
So it read here, save as otherwise expressly provided, an appeal shall be lie from every original order passed under this act. So my learned friend has misled Honorable Court that application was made under this section, under Arunachal Pradesh Land Settlement and Report Act. But it is neither in the application of the respondent, private respondent, nor in the order of the learned deputy commissioner. This law or this section, not even a single space were mentioned, my lord.
Okay.
Then,
Now this order
yes,
at page 43, which is in your favor, page 43. First order of the deputy commissioner on his complaint. Right?
yes. Up to
This-
this, it is junior.
Okay,
Yes. Procedure also is correct, my lord.
okay. Now this matter went up before the commissioner
Commissioner.
or director of land records. Land
Yes,
management.
yes. It was.
Where, was he heard there by the director of management?
No, my lord. It was something like this. Director of management. No. I filed that with the commissioner.
Commissioner means?
Commissioner land department.
Yes,
Okay,
yes.
then it went
Because
to the-
commissioner land department is the appellate authority under this.
Mm.
Then commissioner land department, because this order is that for non-hearing. Without hearing, this order was passed.
Okay,
Because my lord, no proceeding, nothing.
okay, fine.
Then commissioner
Fine.
says, at least you hear both the parties.
Fine,
Then
fine. Now, Mr. Counsel, let us appreciate one thing. There is an order at page 43 in your favor. Let's say that is a 145 order. Let's put it. He goes up on a provision of appeal, which cannot be done under order passed under 145. Provisions of 83 cannot be used. Right?
Hello, sir.
It goes up. Whoever, the government director, says that you, commissioner, now deputy commissioner, rehear the matter. Right? This rehearing occasions. Now, why did you not challenge that order at that stage? Because here the element of the land revenue thing had come in. And the order that exercise was under the provisions of 83 too. Right? Why was that order not challenged?
My lordship, I was still under the dark. There was no case regarding that, as my learned friend submitted. So I was not a party.
That's
It was
this
complaint.
order dated 22/10/21.
Yes.
Was it passed without hearing you?
Yes, without hearing.
No hearing.
No hearing.
No, which one? 22/10/2000?
Ah.
No, my lord. Even lawyer was there, complainer was there.
How do I get it?
Yes, my lord. It's already mentioned here, my lord.
Come on, show that.
Yes, my lord. I will just show here. Yes, he was there only, my lord. Page number 48. Counsel is
Okay.
also 7. Also appeared Landi Appa along with it. I think he is only
Mr.
advocate.
Tang, again your day.
He
He
argued-
before the court.
No,
Page 48.
That is why, that is why this order has been brought before your lordship in challenge. This was inconsequent. This order was made inconsequent to the complaint. Only complaint, not the case. Not making case, making any other person, deputy commissioner or me as a party. So juniorly, I was in that side, your lordship.
Okay, fine. got it.
Yes, I was
Then-
in that side. So I was abruptly called since there is a complaint against you.
Okay,
So I was called to the chamber of deputy commissioner, not in the revenue court, your lordship.
okay.
So
Means you mean to say there was no notice given to your
no,
client?
no notice.
You
no.
were called, maybe your client was there to that office that conduct the hearing. Now you have filed a revision against that.
Yes.
Show me the statements there in this connection. Specifically to that point. I'll have that order interfered, exercising my power. Don't worry. So this opportunity of hearing that you are now taking up is not there in your revision petition. I just want an answer on 2 points. One, you had an opportunity before the district court, this deputy commissioner, when the matter was remanded back. You knew about it. If it was your case that this is a proceeding under 145, you cannot have a hearing on this point. One, because the issue that was framed or the issue that was heard was also the validity of the allotment order, right? In that situation, you did not approach any court because you could have approached the session court saying that this order, or you could have come here in a writ petition saying that this is a proceeding under 145. Now you cannot have it under the land records thing. You will have to continue under this. You did not. You allowed that proceeding to take place. Then you went before the commission, before the session court. Now you come to your grounds. Grounds are the main. Page 61. Just clarify. This is something troubling me. Just clarify this. You see the grounds. Come to ground G.
So where are we, my lordship?
Page 61, G.
I'm there.
G.
Yes, I'm there.
For that, the crux of the cases and appeals thereof were in matter of section 145, which confines to possession, right? But learned deputy commissioner went to decide the title by cutting off 200 square meter from the allotted land of the petitioner. Arbitrary and whimsical act should not be allowed to take field of law. You are not questioning the proceeding. You are only saying that 145, there is a declaration. So how could you do it? But the order of the deputy commissioner, very specific, that there were two issues before the order, before the court. One was legality of allotment. Second was possession of disputed plot. Now, one thing, if you can just show here, in that order at page 30, show me the schedule of the land. That this is the land that was there before the executive magistrate. 600 square feet. Just show me that.
before coming, my lord, before coming to page 30, page 24, based on page 24, in pursuance of the government approval accorded by the order number LM 294, 2019, 2163 dated 13 March 2019. Srimati Landiappa, wife of Sri Landi Tagya Taki of village Hari, PO PS0, Lower Subansiri district of Arunachal Pradesh, is hereby allotted a plot of measuring 600 square meter. So this much of land was placed before learned executive magistrate Itanagar for decision of in the trial under section 145 CRPC. Then coming back to page 30, my lord. Page 31. The material pact placed before.
Mr. Counsel,
Yes.
can you just also clarify whether this gives you the right title and interest, this order, page 30?
Page.
Or is it just an order confirming your position, that you are in possession of this?
Yes, this is an order confirming my position, absolutely. And the order which is giving me title is at page
Mr.
24.
Mr. Counsel, this land allotment order and page 30, 24 and 30, if we read together, it is confirmed that your client, the petitioner, is in possession of that much square foot of land.
600
square meter.
Yes, 600 square meter.
Now tell me, if tomorrow somebody puts this to challenge, land allotment order, will this order of the executive magistrate act as a bar? If I have understood your projection is leaving that criminal case going and getting converted to a civil case. That we will deal. Tell me one thing. If tomorrow somebody challenges that land allotment, it is open to challenge. Everybody, democratic country we live in, we can challenge for genuine reasons. Now, will this page 30 order of the executive magistrate act as a bar, that no challenge can be maintained?
Of course. So every individual has every right to challenge anything. But further, my issue is whether a deputy commissioner can act as a judge against his own order, against his own allotment order, and one more order passed by him by cancelling the application of the respondent number 4. This is my question. And is he okay, in continuation, even if 145 can be challenged by the respondent number 4, but it is not before the deputy commissioner. What is my issue is 145 order can be challenged in a title court. That is at least CGM, Chief Judicial Magistrate. So deputy commissioner went to decide the title of my land which has been allotted by him himself, my lord. As he did in my case. He cannot do that. No. Then further, as submitted by my learned friend, Mr. Sonar, this appeal was made to the commissioner, land management, government of Arunachal Pradesh. Of course, he is a government, it is an appellate authority. But my question, why this complaint has been taken cognizance by Director of Land Management. He is not a government, my
The
lord.
first question that I asked
Yes,
you.
he is
was-
not, he is not a
That's why,
government.
Mr. Counsel, the question I asked you, when the matter was remanded back by the commissioner, why was that not challenged? That action not challenged?
Lordship, this complaint
Then
letter
you
was not.
replied- Then your reply was that we did not know. It was only on the date of hearing, I was asked to appear by the commissioner. But that is not supported by your statements before the first revisional court. Therein you don't take.
No, my lord. I'm sorry. I'm sorry. Pardon me. This endorsement letter, neither endorsement letter nor conningers was taken in this matter by the Commissioner Land Management. The cognizance of the complaint was taken by the Director Land Management.
I still tell you.
He is not.
It is wrong.
It is wrong.
You permitted it to continue.
I was not made a party. I was still in the dark.
That's what I was asking you. Show me that simple statement in your revision before the sessions court. In the revision petition, just show me the statement that you have made, that you did not have an opportunity to contract it. This is a criminal case. They had converted it to a proceeding under the Arunachal Pradesh Land Records Management, that act. That should have been your case. That, see, this is not maintainable because this is a proceeding which is continuing under 145. It's an appeal under 145, which he has illegally done before the management, before the deputy commissioner. You have not taken any plea of that sort in your revision. I'll have to exercise my jurisdiction. I can exercise only on the grounds you take. Because I'll have to tell that the order passed by the Sessions Court is erroneous. Because for that, I'll have to hold that the deputy commissioner's order is in continuation of that 145 proceeding. If it is in continuation of 145 proceeding, Session Court had the jurisdiction to consider your revision petition. I'll remand back the matter. But for that, two things I'll have to record. One, that the proceeding by the deputy commissioner was under 145. And two, the Session Court in dismissing your revision petition erred. I'll give you one more instance. No hurry. No hurry, I am here. This is also matters I'm learning. We'll learn together.
Yes.
You come to page 46.
I'm there.
Page 46.
Yes, sir, I'm there.
1, 2, down below 1, 2. Have you seen? 1, 2, down
Yes,
below.
yes.
Just paragraph above that.
Yes.
Aggrieved by the aforementioned impugned order passed by the learned so-and-so, the appellant return a representation for revocation of land allotment number so-and-so issued in favor of the opposite party, Landi Yada Yapa, before the deputy commissioner. In his prayer, appellant prayed for so-and-so, 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 so-and-so. Now, here, he is not challenging the order of the executive magistrate. He is challenging now. Maybe that gave him a ground to challenge your allotment order. He cannot be prevented, or you will have to show me that he is prevented.
This is Your Honor order. I'm reiterating my submission. Made out of the complaint. Not of any proceeding. Wherein I was made party and I should have been given opportunity of being heard. So very genuinely submitting, I was in dark side. In all these official proceedings, my lord.
Okay,
Yes, it was
okay.
not, all these orders are not the outcome of the any what
You mean to
called
say there was no
legal
notice-
proceeding.
there
Yes,
was no
yes.
Notices given to you.
Notice,
Notice was not given.
not
You were not
notice
given
was
a-
yes, notice was given to me in pursuant to the complaint
Which complaint?
made by the respondent number 4 to the commissioner land management.
What
And
is it? Where is that? Where is that notice?
that
Let's appreciate that notice also. The counters of that notice. This is basically the issue.
My lord.
If we hold that it's a proceeding continuation of 145.
Yes, my lord.
Then
Then my
the
lord,
order of this
my lord, my
will
lord,
happen.
my lord, then.
But we hold that 145 gave you a grievance, you went to the jugular vein and you challenged you caught the client here.
Definitely, my lord.
And you caught her there and said you went and challenged the land allotment order.
Land allotment. Because
So that is a separate proceeding
no,
order.
because, my lord, you see, Act confers me right, my lord, and the Act confers the power to the deputy. My lord, here, my lord, when the deputy commissioner exercising 145, he is only executive magistrate. It's a completely separate jurisdiction. Now, when
No,
the
he has taken that in page 45, 48.
My lord,
The issues are.
my lord, and then the deputy commissioner, my lord, under the Act, he is a deputy commissioner.
So where is that notice given to you?
notice
Where is the notice?
I must say,
Mr. Sona, where are the notices issued? It's not on record.
So far, my lord, but that ground has never been taken.
Forget it. We want it.
Well, here also not taken.
We want it.
My
We
lord,
are adjudicating. We will adjudicate looking into all aspects.
my lord, my lord.
Let's
Here-
say he has taken a valid plea. He does not know that this is not a proceeding under 145 continuation. So I should also know.
From the order, my lord,
Forget the order.
my lord.
Show me that notice. Mr. Counsel, when can you give me that notice? Tomorrow? Or tomorrow is all the day after?
it is whether it is with my client or not, I have to
See, you
the
have
confirmation.
You have submitted that notices were issued to you. Little bit before. See, I have this bad habit of not taking notes. I rely on the recording. I just rewind it and I get my points when I dictate.
Absolutely,
So
absolutely.
everything, that's why I keep on asking questions so that if I'm reserving it, I get it from there. You just rewind it, I get my answers, I can pass my orders. Now tell me whether notices were issued or not. You said yes.
Notice has been issued.
Your friend
I will
can
submit
just
it. Yes.
confer with your client. Your friend can confer with the client. We want to see what that notices are, under what provision it was issued.
My lord.
I shall report by tomorrow.
My lord, this is the, my lord has rightly.
Satisfied. I'm satisfied.
Section 83, my lord, reverted back matter. And specific deputy commissioner, you consider under this.
That is why I'm saying whether the deputy commission, because see, it's not the question whether the proceedings are under 83 or not. The question is whether he knew that this was a proceeding under 83. Do you get my point?
My lord.
The issue is whether he knew that this was, because he may have gone there bona fide as the council is submitting. He himself represents. I did not know that this was a proceeding which has now started because it was remanded under 83.
Yes, I have understood. Now, subsequently, after passing order, this, my lord, let's assume this is under 83. My lord, there is a remedy he has. I am not saying that he doesn't have a remedy. He has a remedy. My lord, he has a remedy of filing appeal against this order to the commissioner. But what he has done is that filing the criminal revision petition, saying that 145, because now, my lord, is very clear from the order. Deputy commissioner has, my lord, will say, under section, my lord, let's understand, under section 45, a deputy commissioner cannot cancel a land allotment, my lord. From the reading of the order.
No, it cannot.
Cannot.
Because
From
that
the-
is a
it is
different ballgame
Yes,
altogether.
from the order itself, it is clearly established deputy commissioner has exercised its statutory power and thereby cancel the excessive allotment. My lord. Now, my lord, what is the remedy? Two remedies are there with him. Still, he has a remedy, my lord.
He can go. That will provide.
He can file either appeal or he can come to the writ petition saying that, you see, no notice has been served to me. But my question is that how you can file a criminal revision petition under section 145
No.
against the order?
I just want to know that if, say, this is happening, if this proceedings happen, it should not happen in future. If a notice is issued, then the notice must specify that this is a proceeding under this act, so that the person is not prejudiced. Now, see, this is a revision. Indirectly, the order of deputy commissioner is also before me. Do you get my point? So if I find that this person did not have notice that this is a proceeding under this, I can interfere with both the orders, remand back the matter. That power is with this court. To satisfy that I did not touch the order of the deputy commissioner, I must know that the procedure there was followed. It's a question of jurisdiction.
Otherwise, a question will
Procedure, the only thing is, revision means what? That authority, whether it followed the procedure required.
No, otherwise, my lord.
Otherwise, your session court, I'm convinced. But I also want to know.
But let's assume, my lord, let's assume for the sake of argument, no notice was issued. Even under section quoting section 83.
Then
assuming, my lord.
Then how does he know?
Assuming. Now, assuming, my lord, this order has been deputy commissioner has been filed without intimating him that this action has been taken under section 83. Assuming.
Then,
for the sake of argument. Then, my lord, what will happen? The order, the reading of the order, impugn order.
No.
My lord, my submission.
No, there will still be a doubt.
My lord.
Because he is not put to notice. What remedy would be is, we will set aside both the orders, we will send it back to the deputy commissioner. Now, hear this matter under the land records.
My lord. Here, my lord, because my lord, he has a remedy. Because ultimately, my lord, reading of the, my lord.
Mr. Sunar, a man will determine a remedy by understanding the procedure followed. If he finds that this is under 145, he is convinced it's 145. Because I've seen his revision. He is convinced. At that point of time, see, this is 145. How could you do that? Cancel my allotment order, right? Now, if that notice specifies that this is under, because why I'm saying so, the matter was remanded specifically under 83 to hear it under 83.
Correct.
So the deputy commissioner must refer to that. If that reference is there, that is the end of the matter. If not, then we will have to think whether he had an opportunity to place his case before because he might have gone before the deputy commissioner saying, say, I have 145. Nothing further is required.
My lord, the one thing submission here, my lord, is not it will be so imprudent the person petitioner to think that a person will file appeal against order against a deputy commissioner.
All are not Rajesh Sunan.
My lord, here, my lord, he knows all the order itself says, my lord.
Yes.
Will
you have that notice.
Notice by tomorrow I shall place it before your order.
Wednesday.
Tomorrow
I'm not coming. Wednesday. Otherwise, I've heard.
My lord, one more point. My lord, let's assume for it, right? Because my lord knows the second proposition of law. Quoting section, reflecting section is not. My lord, here is the nature of my complaint. If he knows the complaint, that I am not challenging the 145%.
Say, this deputy commissioner, while deciding that issue, also touched upon your possession.
Yes, sir.
Possession is related to 145.
But that possession is not given to me. Here again the issue, my lord.
Forget it. 240 is claimed by you.
My lord, because it's a government land.
240 is claimed by you.
Well, it's a government land. Now, my lord,
it is at that stage, this court, while reading, got doubt. That's why so much time.
My lord.
Wednesday. Oh, no. You just let us have it. Otherwise, your plea with, if it is 83, the order of session court goes, we will allow him to have avail his remedies. We will not leave him remedies. But just want to convince myself. on 22nd. Mr. Sona, Mr. Consul, 22nd.
22nd of this
20
month, my lord.
This month. Heard the parties at length. List this matter again on 22-1, 22-2.
22-2.
22-2. Madam, you have something to add?
I'm for Deputy Commissioner, Your Lordship.
Yes, yes, you are the main man. Yes, yes. What is your stand? That small area.
Here, what here is saying is that Your Lordship may come from our affidavit, Your Lordship. This one, para 5, Your Lordship, page 3.
Takam Nicholas. Yes. Para 5.
5, Your Lordship. What we are stated that, Your Lordship, in this criminal petition, Your Lordship, there is a clear provision in the Arunachal Pradesh Land Settlement and Records Act 2000 for appeal which shall be represented by concerned secretary. This is land management, and your deponent admits that the Director Land Management Government of Arunachal Pradesh Itanagar has forwarded the case white number LM127/2020/114 dated 29/4/2021 and stated that there is no record of personal hearing taken to the appellant by the lower court, which is essence of quasi-judicial process before any appellant. Therefore, you are requested to take up the matter at your level by summoning the party concerned for redressal, Your Lordship. But what we have said, and also Your Lordship may come to para 6, Your Lordship. May I read, Your Lordship?
Just a. So, you say 22-10-21 was conducted under section 145. Proceedings under 145. Why didn't you place this before? Come to page 4 of their affidavit.
I don't have that.
Yes.
Page 4. Top. Page 4.
Yeah, yes, sir.
Respondent begs to state that in pursuance to a direction of Director Land Management, Itanagar, both the parties were summoned and accordingly proceeding was conducted under section 145. Under 145, how can he cancel the landowner? That is why I wanted the notice. Go further. So he has jumbled up everything. So how can you hold the poor lady to be in the error? Think over it. So now that order passed by the session court may not be wrong.
Passed by the session court.
Because of all reasons, of everything, the possession she has, that 145, whatever says, but the land allotment order, neither the deputy commissioner could touch, nor the session court.
Here is the issue is my lord.
See, they are saying 145.
This is very unfortunate, my lord.
I don't know. You get me that. That's why I said, still, get me that notice.
Question before my lord is fine.
See, he says two things. He says matter remanded back by the director, 83.
Because of my appeal.
But he says, I continued the proceedings under 145. So
Now-
if it is 145, what is the mistake committed by? So she did not get an opportunity.
Opportunity, my lord.
Because she did not get an opportunity to bring on record natural justice, to make submissions with regard to that land allotment. She made her submissions with regard to possession.
With regard land allotment made.
I'm telling you, a presumption can be drawn. Get me that notice. That is no.
Now the issue is here, my lord. Because my lord will see the starting point on the basis of which.
This was not on record yesterday. It was not in the file, madam. It was not in the file alone. Come on, I missed this.
Now the,
Quick answer.
now the my lord question is,
Head of parliament. So you state.
like, even suppose my lord deputy commissioner.
Deputy Commissioner.
My lord, suppose it is something like that.
We are not going by the reasoning of the deputy commissioner. I'm not going.
It is something like that. I have filed a, because my lord will see on under whose application this entire proceeding has started.
Why do you go that far? When the director has remanded back the matter under section 83,
My lord,
we will have to understand it to be a proceeding under section 83.
80. But now the question is,
But I'm looking at the point of view of the appellant, the revisionist. We'll have to look as to what case was he required to meet before the deputy commissioner.
from the order, my lord, of the deputy commissioner, from the order, it's very clear that the issue of
See, this deputy commissioner is wiser after the order of the session court, saying that this is not a proceeding under 145.
not after the session court.
I'm just. Poor court, let it express. It's wiser, there is a judgment before him that this is not a proceeding under 145, so we are not entertaining. Still, he files an affidavit saying that it is 145. What do this court infer from that? That the session court was taken for a right. The learned session judge was taken for a right. Wrong submissions were made. So, before we conclude, let us have the actual fact, and that is the notice. Because he says notice was issued. It's a reference there. Madam, you also get that notice. On the next day, madam, I forgot your name.
P. Pangu, Your Lordship.
P. From learned, you are a government advocate?
Yes, Your Lordship.
Learned government advocate representing the respondent number 4.
3, Your Lordship.
3,
Yes, Deputy Commissioner.
Deputy Commissioner. Deputy Commissioner, which district? Deputy Commissioner, which district?
ICC, Your Lordship.
Deputy Commissioner, Itanagar. No,
Itanagar, yes, Your Lordship.
Itanagar. No. Deputy Commissioner, Capital Complex,
Yes, Your Lordship.
Itanagar,
Itanagar Capital Complex.
shall on the next day produce before this court the records of the proceedings in case number DC / ICC / JUD / Miss dash page 45 underlined. Right? List this matter again. When can you get it, ma'am? Don't take more than 10 days.
10 days, 10.
You have time till 1st, whenever you want it. 31st, we within 31st.
Okay, Your Lordship, 31st.
Huh? 31st. Make it 30th, Tuesday. We have some time, 30th.
February is not 30, up to 29.
No, 30.
February is still 20.
Oh, sorry.
28 years.
Up to
I was
29.
looking at January. I was looking at January, sorry. We'll have it on 27th.
27.
Okay, Your Lordship.
Huh?
Perfect.
Yes.
No, 26th is a holiday. You might have a problem in getting the records.
Okay, it's 20
You have it on 28th.
28.
28 too.
And,
And Mr. Sunar, see page 45 once more. See the heading. Orders under section
Well,
145.
that's why.
It's a wrong quoting.
Your
But I
Lordship,
want the order.
may I, Your Lordship, order copy maybe, sir?
Madam, quick copy.
It has happened something, my lord. I have filed a writ petition under section 226. Then the court says that I have passed the order under section 482 of this year. This is what happened. Because
Copy of the order, be punished to Madam का नाम लिख दीजिएगा. Yes, next.
much of the.
Yes, Your Lordship.
This is Village around.
It's thanks for having this opportunity. Yes.
Well, this is also something like, the required to be heard by the village authority.
Okay, that case.
My lord.
Hmm.
Yeah, your lordship, the respondent is yet
Now we
to
are
reply.
a little bit more educated on that.
My lord, that simple case is, my lord, and my lord, I have lodged a complaint before the, my lord, the village authorities, and that has been referred to the village authorities, and the village authority has, my lord, referred the same things to the, sorry, the village, my lord, sorry, they call Gaon Bura Association, my lord. But as per the, my lord, the Civil Code Act, my lord, there is a provisions, whatever the name called, they have the power and the jurisdictions to settle the
That's
matter.
true. When have you fixed that matter, Mr. Kaushik's? Cup fix where?
Item 10 or 11.
Was this the end of 29.
That 50, my lord, it is 50.
29. We'll have it on 29. Similar matter is fixed on 29.
Yes, ma'am.
We'll have it together.
The respondent is yet to file reply.
Forget it. He does not want it. What is it? You don't want to file a reply.
My lord, the reply may not be required.
It's a point of law.
Yes, only points of law, my lord.
Upon hearing the learned counsel for the parties, list this made as prayed for. List this matter again. As prayed for by the parties, learned counsel for the parties, list this matter again on 29.
My lord.
29 to 2020.
Development.
Hearing. Motion. Yes.
Before rising of the court. But if the accused person was arrested on 15th February. However, the FIR is of August 2023. After more than 5 months, he has been arrested.
No, wait. I've not been able to go through it. Let me just go through it. Okay.
And he is a retired director, having so many ailments.
I think there was another matter today. This scam with regard to appointment orders.
Yes, my lord. That has been withdrawn, my lord.
Oh, that has been withdrawn.
That has been withdrawn.
CD will be called on 23.
Wait.
CD is required.
23 is a very auspicious day.
No, wait. Man is behind the bar.
He is within the bar because there is a serious allegation.
Only allegations, Lord. Because he has already availed anticipated bail in other district. Similar nature allegations, similar agency. There are 8
Where is those orders?
Lordship, it's annexure 4, page number 39, 35 to 39.
See, the only problem here is if these allegations are true, you have done an offense. That's a different thing. But at the same time, you have prevented certain meritorious people from
That
coming.
is allegation. That is the allegation.
I said
Because-
the allegation is
because he is the-
with some substance.
he was the
It's not
director.
only you doing an offense, taking money. There is another aspect that you have prevented. You have acted against the interest of the society.
Lordship, more so-
And here it's teachers.
More so, Lordship, already investigation done, my house has been searched, entire money trail has been done, nothing was found.
Money is not kept in the house.
Not even the bank transaction, no.
But the allegation against you is that you have received 20
There are-
lakhs.
There are DDACs, there are some other officers. How can a single man?
No, it's conspiracy. What are the sections against you?
Section against is 120B, 420, 409, 468.
Then 120B is there.
My name.
Okay, we'll have the case diary.
23.
Heard Mr. K. Saxena, learned counsel for the petitioner. Also heard Mr.
Opana,
additional PP.
No, special public prosecutor.
A special public prosecutor.
SIC, vigilance.
SIC, bracketed BIJ, bracket over. So, call for the case diary of SIC, bracketed VIG, bracket over, PS case number 04-2023, under section 120, bracketed B, oblique 420, 468, oblique 471, oblique 409. Madam, it's here. Page 3, I've marked it. Underline portion. The underline portion. List this matter again on
23. My lord, as per my instruction, my lord, he was produced today, my lord, and we have taken another custody for 10 days, my lord. That has been allowed by the special.
He is shown arrest in another case also.
No, no, my lord, he was arrested, my lord.
You have taken custody for 10 days.
Yes, another 10 days.
Custody has been
That's extended. That is of no use here. We'll have it on 27th
27th.
Lordship,
or
in that
28th.
case- No, Lordship, in that case, 1st of March.
1st of March. 1st March.
Either
One
23
trick.
or-
One trick. One trick.
My lord.
Because taken in custody, they'll have to do some interrogation.
My lord.
So let them do that. Get the completed updated CV.
They could have served with section 41A notice, at least.
My lord, 409 is there. More than 7 years. Obligement.
Yes.
And may it please
The
your
names
lordship.
created certain confusion. Now,
Yes, Lordship, the allegation herein is the same as the item number 2 and 3 of
what are the sections involved here?
section of 352, 447, 506,
352,
506, 323,
506, and
323,
333,
447, of,
447,
34 IPC, and read with section 3 of PDPP Act.
section 3 of
PDPP Act.
what is that PDPP?
Destruction of public property.
Okay.
And Lordship, the informant in item number 2 and 3.
The allegation is against them.
Allegation is almost same, Lordship.
Means no.
Similar.
You had made allegation against them of having a relationship.
Yes.
And that is the result of this. That is your case.
Yes, Lord.
Okay. Yes, madam.
Yes, Your Lordship, I don't object on interim if Your Lordship is.
And I'll give interim.
Since another matter, the Lordship has called for the CD on 27th, this matter may also be.
27. Okay. This is PS case, BSR PS case number, no?
Same PS, only the number is different. The FR was lodged on different day.
That was
first FR was lodged on 8 to 2024, and second this FR was lodged on 9. Very next day.
That FIR was of 8.
8.
This is of
This
9.
is of 9. After 45 days of Ellis open.
And in that FIR also, there is a statement that that lady had put up a complaint. This is the officer?
Yes, that's
yes.
informant
And
had officer.
given it to that police.
Yes.
But it seems that that is a wrong statement. Anyway, interim. Your name?
R. Ingo. R. Ingo.
Ian? Sorry, I'm
ING.
I'm just getting in touch.
In fact, Lordship, the applicant name
You
is
have
not-
your statement recorded. Both. Give it to me. I'll pass on.
Lordship, same order and item number 24 and 25.
Both interim orders with conditions fixed on 27.
7th.
Deeply applied.
Yeah, item 23, 24, 25. Yes, madam.
Lordship, I am at the first instance. I'm extremely sorry I was not physically present. But Lordship, this is
It's okay,
a
madam.
FAO.
We have this facility. We can use this.
Yes, I'm so obliged
Yes.
to your Lordship. Lordship, this is an FAO resulting out of an order dismissing my application under Order 9, Rule 13. My dismissal order is is dated 30/6/2023. And I've come because of Yes, Lordship, 2003. Has Lordship got it? It's at page,
Yes, yes, yes.
yes, it's at page 13. Lordship, I'll just read the first passage, this third paragraph. It is the case of the petitioner, defendant number 1 herein, referred to as the applicant, that until receipt of the show cause notice on 25/5/2023 in execution petition number this, corresponding to money suit number 39 of 2020, summons were not received by the applicant. Further, it is pleaded that as per para 11 of the judgment, it appears that on 27/11/2020, notices were issued to the defendants for filing WS on 15/1/2021, but the defendant remained absent, though the plaintiff had taken steps through prepaid registered post. And by order dated 15/1/2021, the leave was granted to the plaintiff respondent for publication in paper, which was accessible by the applicant and the defendant number 2, and the case was posted for appearance on 13/4/2021. Plaintiff had accordingly published the notices in 3 newspapers, namely the Sentinel, the Dainik Akhom, and Echo of Arunachal Pradesh. Now, here is Lordship. Before I proceed further, I would like to place before Lordship that definitely the case was listed before for WS on 15/1/2021. The defendant apparently took steps by registered post, but nowhere were the tracking report produced before the court. The tracking slips were not produced to ascertain that these notices were duly served on me. And despite that, the court below had, by order dated 13/4/2021, had granted, and then the order dated 15/1/2021, the court granted the petitioner leave to publish the notices in paper. But what the court did, court said to publish in 2 national dailies. That was the order of 15/1/2021, if Lordship sees the records.
It says for publication in paper, which is accessible by the applicant and the defendant number 2.
But the order dated 15/1/2021. Yes, Lordship will find at 17/2/2021. 17/2/2000, the records are there. The plaintiff shall publish in any national newspapers for appearance of the defendants and issue notices to the defendants. Plaintiff shall take steps.
মেইন মানি সুটৰ এইখিনি ক'ত আছে মানি সুটৰ প্ৰচিডিংছটো
to 2021.
30? Madam, the
17
date of the Yes.
Yes. So it was in 2 national newspapers, published in any national newspapers for appearance. That was a specific order of the court.
Okay, how was this issue dealt with?
But the defendant, the plaintiff did not do that. He published in the Sentinel, Daily, Dainik Akhom, and 3 newspapers, which was not necessary, and none of them are national newspapers. So the court's order has not been complied with. court for in its own wisdom said national newspapers, but this has not been complied with. But nevertheless, the court had assumed that the parties failed to appear, notice paper publication was done properly, and proceeded to hear in the matter ex parte against the petition, the appellant, the present appellant. And a decree was passed for recovery of 1,72 lakhs 07368.5. This is what I am actually aggrieved by. And I came before the learned court under Order 9, Rule 13 for setting aside this order. That give me a chance. I never received the notice. And strangely enough, Lordship, this suit was filed on 18/9/2020, and the defendant number 2 was dead by that time. So this suit was filed against a dead person. That, of course, would be heard when I come for before the, if your Lordship sets aside this order and allows me to proceed in the trial.
So basically your question is, your answer is that you had no notice. And
I had no
the
notice.
manner in which it was directed to be published, it was not published. So
Not published
you
in
take a plea that you should have published in a substituted service was with a rider that it should be in a national newspaper. Not having done so, you do not follow the court order. So you take a plea that I had no notice. And the
Yes,
second plea, which may not be relevant here, that respondent number 2, by the time this money suit was filed, was no longer in this world.
Yes, and Lordship will also notice I have another plea. One more, which is very important, that Lordship will find the suit was filed in 2020, 18/9/2020. Thereafter, it was during the pandemic, Lordship. This entire thing happened during the pandemic, where people did not read newspapers, communication was disrupted, the entire country was in a turmoil, we didn't know what to do. So it was during this pandemic, and courts were working off and on. There were orders from the Honorable High Court to take up only important matters. And this is what was going on. So during this pandemic, Lordship, one has to be extra cautious to ensure that the notices are properly served. They say registered postal service were practically not functional, Lordship, except emergency.
No, by the time 17 to 21, and when was the publication made?
Publication of the newspaper was made on 26/2. That time there was a small Lordship window. It was during the window. 26/2/2002.
Papers were coming out.
Yes, there was this
Mr.
window.
Dekar, what do you say?
My lord.
Yes, Mr. Dekar.
My lord, my submission is that as my senior counsel has argued that tracking report was not submitted by the plaintiff. My question is that whether submission of tracking report is mandatory or not. My humble submission is that submission of tracking report is not mandatory, first of all. And I am coming to the second point, my lord. In the national newspaper, my lord, what is the mandate of the law in these circumstances where a substituted service is ordered by the Honorable Court under Order 5, Rule 20, my lord? If your lordship have a look at Order 5, Rule 20. This is the substituted service, my lord.
Yes.
Where the court is satisfied that there is reason to believe that the defendant is keeping out of the way for the purpose of avoiding service, or that for any other reason the summons cannot be served in the ordinary way, the court shall order the summons to be served by affixing a copy thereof in some conspicuous place in the courthouse, and also upon some conspicuous part of the house in which the defendant is known to have last resided or carried on business or personally worked for gain, in such other manner as the court thinks fit. The next one, my lord, 1A, where the court acting under sub-rule 1 orders service by an advertisement in a newspaper, the newspaper shall be a daily newspaper circulating in the locality in which the defendant is last known to have actually and voluntarily resided, carried on business, or personally worked for gain. That is the statutory provision, my lord, where substituted service is to be given, my lord. And in that case, my lord, the plaintiff has rightly made given the advertisement in the local newspaper in both in English and vernacular in Guwahati and in Arunachal Pradesh also, my lord. Next, I'm coming to the issue that as at the time of pandemic, my lord.
Yes.
Lordships, I mean, look at the orders from 15/1/2021, my lord. 15/1/2021. Lordship have the orders.
Orders of the in the Manisur. Orders in the Manisur.
Yes, my lord. Order in the Manisur. Yes, yes, my lord.
Dated
15/1/2021, my lord.
Fifteen 1/2021.
Yes.
Yes.
Today, I'm reading, my lord. Today, the present case is fixed for SR and WS. The plaintiff is present along with the learned counsel, Mr. Todagado. The defendants are found absent. The learned counsel for the plaintiff has submitted the step taken report.
Fine, I've read it. You can proceed further, Mr. Decker. 17-2.
17-2. Thereafter 17-2, same thing, my lord. There was no coronavirus at that time, as the court's order will reflect later on, my lord. Today, the present case is fixed for SR and WS. The plaintiff is present along with the learned counsel, Mr. Todagado. The defendants are found absent. The learned counsel for the plaintiff has submitted the step taken report. Next, my lord, on 13/4/2021, it was proceeded ex parte. 13/4/2021, after about 2 months, it was proceeded ex parte. There was no coronavirus also, no pandemic till April, my lord. It is reflected in the order itself. But in the next order, my lord, order dated 31/5/2021. In that case, Guwahati High Court has issued SOPs for pandemic, my lord. The pandemic has come on 31, means in the month of May itself, not in January and February, my lord. So, and the most importantly, my lord, how the defendant, this appellant has appeared in the case in the same address in when the executing court has issued notice in the same address, whatever was in the suit also, in the money suit also. Means after receiving a show cause notice that why you should not arrest, then they came for this application order 9 rule 13.
The order for proceeding under ex parte came
Yes, my lord.
on 31/5/2021.
No, my lord. It was on the earlier date, my lord. 13/4/2021.
Where is that exact?
Earlier order, my lord. Earlier order.
Upon perusal, it is found that 2 occasions summons were issued against the defendant through a prepaid, but the defendant remained absent. Therefore, was directed to issue so and so. Is there a second page to this order?
Yes, yes.
Yes, Lord.
Oh, that is missing here. That is missing here.
There is second page. The defendants remain absent in spite of.
And I'd say. Oh, no, 17-2-13-4. The second page क्यों नहीं है?
After 17/2/2021, the next date.
So ex parte is on 17-2, right?
No, my lord. The order on 13/4/2021, 13/4. It was the proceeded ex-parte.
Yes, madam, any case laws? Any case laws you want to rely upon? Madam?
My lord may fix it on another day because in virtual mode we cannot even produce the case laws also.
Will not trouble madam to come down here. You are a young man, you can come down. Madam.
My lord, I will
We
definitely.
are accepting.
My lord, I will
You
come.
There is no problem.
I will come, my
We
lord.
will not require madam to come. This is enough for us.
My
This
lord,
is
actually.
permissible. Why will she not take advantage of that?
Actually,
I'm so obliged
Madam,
to your
any
lordship.
case laws? Any case laws? Any case laws? Case law.
I'll furnish it. Yes.
Give it
Lordship,
to me.
can I?
This is the. Whenever
I
you
can
want
mail it to. Yes.
No, just give the citations. We will have it out here.
Yes, Lordship, I'll give the citation.
When can we fix this matters? You have any counsel
Next.
assisting you here?
Yes, I can ask someone to appear and give.
When should I fix it?
Friday.
My lord, this Friday it won't be
You appear
possible, my lord.
online. You appear online.
My lord, this Friday it won't be possible, my lord.
Friday.
Well,
would
Monday,
be
my lord,
a bit,
Monday.
because some matters have been.
Monday is a holiday. Tuesday.
Monday we can do it.
Tuesday.
No,
My lord, Tuesday.
It can be on Tuesday. Monday is a holiday here.
My lord, Tuesday.
27th.
Tuesday.
27th.
Obliged,
So, ma'am,
Lordship.
if you can give me the judgments before that, both of you, on
My
that
lord.
day we will have a final hearing and we'll conclude the issue.
My lord,
Absolutely.
I'll do that.
Obliged.
If you have councils, local councils here, kindly give it to them. They will hand it over to the court master.
I will do that. I'll do that. Lordship.
I'll do that.
On 27, we will close it.
My lord.
Heard MS M. Hajorika, Learned Senior Counsel, representing the petitioner. Madam, you are assisted by?
Sanjanan S. Niwar.
Assisted by?
S. Niwar.
Assisted by S. Neva. Also heard Mr. B. Deka, Learned Counsel, appearing for the respondent. Also, hearings remain inconclusive. List again on 27/2/2024 for further hearing. The parties are at liberty to bring on record their respective written arguments, if so advised, along with the citations, case laws they rely upon before the next date fixed. List again on 27, 27, madam, 27/2.
Obliged, Lordship.
Much obliged, lord.